your eyes now, but I know there's always a way. From sunrise to evening, from sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, fix you up, fix you up, fix you up. With these hands and hearts so true, I'll fix you up, fix you up. Daniel, I'll fix you up. Connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. Dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix these hands and hearts so true. I'll fix you up, and I'll fix you up. When the current isn't flowing, when you sit here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken. Make the whole world sing. So don't you worry about tomorrow. Don't you stress about. I've got maintenance for your troubles, and I'll chase them all away. I'll make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, everything's good as you. Hey, Daniel, I'll fix you up for you.
Well, welcome back, everybody. Welcome, everybody. Just remember, everybody is welcome here. All I ask is that you act like adults and don't start no drama in my chat or on my channel. Today is Judge J. Cedric Simpson. I like this judge. Oh, and by the way, I did get all that content uploaded, finally. But here we go with Judge Simpson. Share screen. Judge Simpson. Make it bigger if I can. And here we go.
Court does call the case. People State of Michigan versus Seth Anderson.
Brian Bowling on behalf of Mr. Anderson, Your Honor, who's approaching. State your name for the record, Seth.
There isn't one in there, Mr. Ward. You guys are going to prepare one.
I'll send the name. Just state your name for the record again.
Seth Anderson.
Judge, he's prepared to waive his right to examine.
All right. Is that correct, sir? Yes, sir. You understand that a preliminary examination is submitted and that you committed it? Correct. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution? Yes, sir. People also waive their right? Yes, sir. Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Judge, for purposes of arraignment, will acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, both counts, court will enter not guilty plea. Pre-trial in this matter will be set November 3rd, 2025, 1:30, Judge Homer.
Thank you, Your Honor.
Bond will continue.
Sure.
Court does call the case of the people versus Rashad Ahmad.
And is on behalf of people, Your Honor.
Good morning, Your Honor.
Good morning.
Hi, Summer CP number 68565 on behalf of the defendant.
Rashad Ahmad. All right.
Your Honor, wanted to ask that count 2 be remanded down to the district court.
Count 1 is dismissed of people being unable to proceed. I'll continue the defendant's plea of not guilty as to count 2. A pretrial will be set in this matter.
October 27th at 10 a.m. Judge Washington.
October 27, 2025, what time?
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you, Bond. We'll continue.
Thank
Oh, there's Court. Court calls the case, people versus Mark Cochin. You want to know what?
Good morning, Your Honor. I am Shannon Smith on behalf of Mark Cochin, who stands to my right. Can you please state your name for the court?
Mark Cochin.
Your Honor, today, in fact, a written examination of the staff of people are unable to proceed.
And Your Honor, based on that, the defense will be asking the court to dismiss this matter.
People being unable to proceed, this case is dismissed as without prejudice. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case, People State of Michigan versus Afif Ibrahim Alawar.
Good morning, Your Honor.
All right. Back to it first. We have an interpreter present. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear and affirm that you interpret accurately, completely, and impartially, using your best skill and judgment in the matter now before the court, so help you God?
I do, Your Honor.
All right. And good morning, Madam Interpreter. In this matter, did counsel state their appearance?
Good morning.
والأسامي
For the people.
سيدة اسمها المحامي له الشعب
Brian Bowling on behalf of Mr. Alawar.
براين بولينج نيابة عن الأعور سيد الأعور.
Sir, can you state your name?
سيدي ممكن أن تذكر اسمك الكامل؟
عفيف الأوار.
عفيف الأعور.
Thank you.
شكرا.
It was set for a competency hearing. However, when the forensic examination was ordered, there was no order prepared, so no interview has taken place.
لأنه كان هناك أمر للفحص الطبيب الشرعي ولكن لم يجري هذا التطبيق الاجتماعي.
So I will reorder
بدي
forensic evaluation.
سأطلب التقييم الطبي لك.
And I will reset the competency hearing on a Thursday, December 11th, 2025, 9 a.m.
9 a.m. Your Honor.
Yes.
إذن حدد موعد في المستقبل نهار الخميس بشهر 12 يوم 11 الساعة 9 صباحا. Yeah, I will write it to me on a paper and I will do it. He asked me to write it on a paper. Yeah.
His bond will continue. Thank you.
الكفالة ستستمر.
I'll serve the order right now, Judge.
Thank you.
Have a seat.
ممكن تجلس هنا.
Mr. Bernstein and Mr. Johnson's clients are.
Yes.
Thank you.
Know what we're doing on that.
I will receive it.
Court does call the case.
Cook for the people. Good morning, Your Honor. Edward Drugas on behalf of Joshua Pelfrey, who is approaching. Oh, sorry. Joshua Pelfrey.
All right, what are we doing?
Able to proceed. Your Honor, I would move to dismiss.
People being unable to proceed. Case is dismissed on the defendant's motion. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Delory and Doral.
Morning, Your Honor. Raymond Cook for the people.
Morning, Honor. Sam Bernstein with on behalf of Mr. Durrell, coming up to the podium. Delory, can you please state your name for the court?
Delory and Doral. Thank you.
This is the date and time set for preliminary examination on this matter. As we discussed at the event, people are requesting an adjournment. I believe that there's no objection. Defense counsel, for the record.
This case will be adjourned. And it will be adjourned to September 30th, 2025, 12 noon before me.
Got it. Thank you, Your Honor.
Thank you. Where is he? Mr. Bernstein, do you see Mr. Johnson out in the hallway? Can you tell him his client's coming out?
Yes.
Where is he?
He's right.
He's not Zoom, Your Honor.
Is he?
Respectfully request.
Okay.
So I'm just trying to get a sense of. Good morning, Your Honor.
Good morning, Miss Belthead.
Very good.
It's the only time it's gonna happen today.
All right. Well, I don't have anything in front of you today, so that'll work.
It's because I was concentrating.
Yes. Yes, I understand. Me too.
Yes, we- Ron Brown is on one side.
Well, but they're a customer.
Mhm.
Damn. Court calls the case of the people versus Barrage Scott, all four cases.
I'm about to bring on behalf of Mr. Scott. Good morning, Your Honor.
Good morning. Your name?
Oh, Barazante Scott, Mr. Judge Simpson, sir.
Did you get new glasses?
Yeah, I did. I can't see.
Can you see now?
Yeah, I can see.
Okay, that's gonna be good. Okay. All right, what are we doing?
Today, the people are not able to, on case 25 F20276, would ask that any dismissal be without prejudice. I believe that Mr. Scott is waiting on.
That's correct, Your Honor. I'm having him sign the examination waiver forms for the other three matters on the docket.
All right, and with reference to 3276, people being to dismiss Mr. Brown.
Move to dismiss, Your Honor.
In that case is dismissed. And then in the other matters, he wait.
Yes, Your Honor.
All right. Mr. Scott, you're waiving your right to a preliminary examination in these other three matters?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the ranking. Preliminary examination having been waived, defendant is bound over to circuit court on the three.
That's right. You are not required to pay. Click the link below to get your savings now.
Counts contained in the case ending 1263, the two counts in case 1265, and the single count in the other matter ending in 0532.
Ron Brown appearing on behalf of Mr. Scott, waive reading of the charges, stand view and request adjourn pre-trials in front of Judge Slay.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all counts. Pre-trial on these matters will be set.
September 25th at 1:30 with Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bonded. Raj, take care of yourself.
You too, sir. Thank you. All y'all take care of yourself.
Michael, you recently came out of your service for the IDF at the Gaza war. Can you describe the tunnels to me, given that you were in there?
My team was in charge of underground warfare. We had a tunnel. There were lockup cages the size of this table. It was like a prison.
It's like, where is Towson? Court calls the case of the People versus Cody Wines.
Morning, Your Honor, Raymond Cook, for the people.
Good morning.
Good morning, Tony. It's like, what day is this?
I know.
I know. I see you and Miss Payne.
It's like a time war.
Like it's a Monday or something.
I don't think I put in my appearance. Lauren Perny on behalf of Mr. Wines. State your name for the record, please.
Cody Michael Wines.
Your Honor, the time set for preliminary examination. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed. Case is dismissed. That's on defendant's motion. Thank you, sir. What? What? I can't hear you.
That's all I have ready for you at the moment.
Wow, so loud.
I believe it's fairly clear, but I don't have his pocket.
What?
I don't.
Where's Akinruli?
It's turned to.
He messed it up the last time. Who was?
Oh, I don't know where she is now, Your Honor. Sorry. But I'm very eager to tell you, I was the one who found her last time. And
Oh, you did?
yeah,
See, I knew, and you should have taken credit for it.
I'm very arrogant.
You Miss Payne.
But whoa.
See, that's how it's done, Warren. Warren Green goes up, disappears for 5-10 minutes, comes back. No. She's probably a hologram, but that's okay. Is this it? Court does call the case versus Candace Fair.
Alan Judge on behalf of the people.
And good morning, Your Honor, Assistant Public Defender Nazi Carey Akinruli on behalf of Ms. Candace Fair, who's approaching. Ms. Fair, state your name for the record, please.
Hello, Candace Fair.
Thank you.
Your Honor, please date time set for preliminary examination. At this time, people are unable to proceed as to count.
So the court will, people being unable to proceed, you're moving to dismiss count one.
Yes, Your Honor.
Count one is dismissed. I'll continue or not guilty plea yes to count two. This will be set for pretrial
October 16th at 10 a.m. with Judge Washington.
October 16th, 2025, 10 a.m. before Judge Washington.
Thank you.
Judge, do you know if that's by Zoom or in person?
How am I supposed to?
Really?
How am I supposed to know that, Ms. Lee?
Almost out of here. I'm sorry.
How
We were,
you want us to find out?
no, Your Honor, we
Ms.
will
Fair, you want
call.
me to find out? Find out.
My boss is already, no, I have to go back to work for the hearing, Judge. Thank you.
Do you have another case?
I've got 3 in front of you today, Your Honor.
Oh, joy. Thank you, Ms. Fair.
Thank you. Have a good one, sir.
Do you know if that's? I have no idea. Court does call the case of the People versus Vincent Lambert.
Your Honor, Raymond Cook, for the people.
Brian Bowling on behalf of Mr. Lambert, Your Honor, who's approaching.
Vincent Lambert.
Your Honor, this is the date and time set for preliminary examination. At this time, the people are unable to proceed.
I would move to dismiss then.
Motion and defendant. That's without prejudice. Thank you.
See you.
He's back.
No, they're witnessing. I'm not going to lose other one. Would you? I talked to them. I don't.
This is a comp review. Court does call the case of the people versus Montel Gatlin.
And the Assistant Public Defender, Cedric, I can rule your honor on behalf of Mr. Gatlin, who's approaching.
Could have done this before he came out. Okay, no, I didn't mind waiting.
Mr. Gatlin, state your name for the record, please.
Montel Gatlin.
Thank you, sir.
So, Your Honor, we are here today for a competency review. I have spoken with the doctor at the Forensic Center. He states that the report will be done by the end of this week.
That it will be done by the end of this week.
That's what he said, yes.
Okay, then what I will do is I'll adjourn the comp hearing, no report, to September 30th, 2025 at 9 a.m.
Okay. Your Honor,
I'm putting it with my PCC docket at 9.
what day,
Pardon?
I didn't hear the date, Your Honor. I
You
apologize.
did what?
I didn't hear the date that you gave us.
Did I?
Was I loud enough?
Or was she not listening? Which do you think it is?
I wasn't paying attention.
Mr. Johnson, why is that?
I was multitasking, but I wasn't doing very well.
September 30th.
Thank you, Judge.
2025, 9
a.m. Your Honor, my client would like for me to address bond, please.
Go ahead.
Judge, Mr. Gatlin reports that he has an address where he will be living with his aunt. He states that he has a job waiting for him to make very good money. He states that he previously requested that my office be removed from his case. He's trying to see if he can raise money to pay a private attorney to handle his matter for him. I think in the meantime, I will reach out to the Office of Assigned Counsel and see if we can get him someone temporarily. However, he wants the court to understand that he is okay with a tether of any sort that the court deems necessary to allow him at least to get out and start working. We know that competency is at issue, but I think that a tether would be able to cover any issues that the court or the people may have in regards to complaining witnesses and safety as well as flight risks, Judge.
Respond.
Your Honor, we ask that there not be a change in bond. Given what the allegations are here, we don't think that a tether by itself would be sufficient. With the fleeing case, we have Mr. Gatlin allegedly fleeing from multiple officers, and officers trying to pull someone over isn't sufficient to make them stop. And I don't know why a tether is something that would make somebody stay at home. Here we have the allegation that but at such high speed that he had 2 children in the car. He left at least some money in your car. And so it will be that it's not high flight risk and danger. So we're asking that why not.
The court's going to deny the request to change the defendant's bond. In this case, the court would find, given those circumstances, at least as alleged, that the defendant would pose a risk of flight, and also that he poses a danger to the community by leaving the children at the location that he did. So his bond will continue.
Thank you, Your Honor.
In the Win with Zinn sweepstakes, you can get a chance to win.
Thank you, Judge.
Thank you. Okay. Court does call the case of the People versus Rashad Keys.
Morning, I'm Raymond Cook for the people.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Keys, approaching to my immediate right.
Your name, sir?
Rashad Keys. This is being attempt set for preliminary examination. People are requesting an adjournment for reasons discussed at the bench. We've spoken with defense counsel. My understanding is there's no objection to brief adjournment.
That is correct, Your Honor.
All right. Preliminary examination along with his co-defendant during this to September 30th, 2025 at 12 noon. And bond will continue as denied. All right. Thank you. Oh, sorry.
Everybody have a good day.
You do the same, sir. Court does call the case of the people of the state of Michigan versus LaDonta Skinner.
Morning, Your Honor. Raymond Cook for the people.
Public Defender Natalie Pate on behalf of Mr. Skinner, who stands to my right. Please say your name for the record, sir.
Thank you.
Your Honor, this is the date and time set for preliminary examination. The people are able to proceed.
All right. Ready to go? Let's go.
Just as a preliminary matter, there is an exhibit, people's proposed exhibit 1. I've discussed with the defense counsel some cell phone footage from the incident. I believe that that's going to be stipulated to being admitted.
That is correct, Your Honor.
Exhibit 1.
Correct.
For the purpose of preliminary examination, Your Honor, yes.
Okay, very good. You may proceed.
Thank you. The people call Brent Bucknam.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God? State and spell your first and last name for the record, please.
Brent Bucknam, BRENTBUCKNAM.
You may inquire.
Thank you. Good morning, Mr. Bucknam. How are you? Mr. Bucknam, where were you on April 10th of this year in the afternoon hours?
I was in downtown Ypsilanti.
What were you doing in downtown Ypsilanti?
I was transporting packages from my place of employment to the post office.
And where is your place of employment?
The Rocket gift store, Michigan.
And you said in Ypsilanti, is that here in Washtenaw County?
It is.
All right. While you were transporting these packages, what route were you taking?
I was going south, crossing Michigan Avenue on Washington Street.
Did anything happen out of the ordinary while you were transporting those packages?
I passed the defendant on the right, leaving about 3 to 4 feet of space between us.
And when you say you passed this individual on the right, were you on foot, in your car, on a bike? How are you transporting?
I was on foot.
What about the other individual?
He was on foot.
All right. And do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing?
It's the man wearing a green shirt.
Your Honor, if the record may reflect that this witness has identified the defendant.
Without objection, record shall so reflect.
When you passed by the defendant, what were you doing specifically?
I was transporting packages. One hand was holding a bag of packages and the other hand was pulling a larger package.
And at the time that you passed the defendant, what was he doing?
He was standing on the sidewalk.
Okay. And how much space was between the two of you when you passed by him?
3 to 4 feet.
When you passed by the defendant, did he say anything to you?
He did.
What did he say?
He said, "You should say, 'Excuse me, bitch.'"
What happened after that?
I ignored it.
Were you able to continue walking?
Yes.
How far were you able to continue walking?
10 feet.
What happened after you got to that 10 feet?
He began making statements in an attempt to intimidate me.
And when you say he, are you still referring to the defendant or some other individual? Okay. What sort of statements was he making?
He was saying, "I will put you in a body bag. I run this street. I will shoot you. I will stab you."
How did that make you feel? Did the defendant ever get physical with you?
Yes.
When did that happen?
That happened about 10 feet later, going south of Washington.
So about 20 feet then from where you initially passed the defendant? What did he do that made physical contact with you?
He punched me in the face,
How many times?
probably about 20.
20 times? And when he first punched you in the face, did you see it coming? Was it from behind? How did that happen?
I saw.
All right. What did you do when you saw that punch coming?
I tried to push him away.
Were you successful in pushing him away?
Yeah, but he got on top of me and began to attack me some more.
When you say he got on top of you, are you on the ground now or are you still standing?
He pushed me down and I was on the ground.
Okay. How long was he on top of you?
10 seconds.
And while the defendant was on top of you, what was he doing?
He was punching me in the face.
Okay. What got the defendant to get off of your body?
I managed to stand up.
So you managed to get yourself up and push him out of the way? Okay. After you were able to stand up, what happened next?
He said, "I will shoot you, I will stab you, I'll take your packages." And he also picked the larger package that was on the dolly.
Okay. At that time, did he have anything in his hands?
Not that I saw.
Did he ever have anything in his hands?
He did.
What did he have in his hands?
He had a large flat blade mechanic style screwdriver about 10 inches in length.
When did that, or when did the defendant get that screwdriver?
As he was running away towards the growing oak property next to the vehicle.
So when did he run away?
After punching me in, after I managed to get up.
Okay, so he gets you on the ground, you get him to get off of you, and then he runs away. Is that what you're saying?
I pushed him to the wall to defend myself, and then he runs away.
Okay. What were you doing as the defendant was running away?
I got my phone out to record
Why did you get your phone out?
because I wanted to have his identity verified.
Had you met the defendant prior to that day? Okay. Were you able to record the defendant? What happened while you were recording the defendant?
He said, "I'll stab you." And he continued to run away.
Never sue the other driver after a car accident. There's a better way to get paid a way bigger check without having to go to court.
At any point, did he raise the screwdriver or threaten you with that screwdriver?
He did.
When did that happen?
As he was running away from the beer cooler towards the growing oak property.
And what did he do exactly with the screwdriver that threatened you?
In his hand while verbalizing, "I'll stab you."
Do you know how far away the defendant was when he made that statement?
About 15.
Okay. When he raised the screwdriver and threatened you with it, what was going through your head?
I was concerned about the stabbing, so I did not pursue it.
So you believed that he would stab you?
Yes.
All right. And after the defendant makes this statement, what happened next?
he continues to run away onto Brian Hope's property,
Did you follow the defendant?
not after he made that statement.
Okay. I'm going to try and hook up, and if I may publish or going to move to admit what's been marked as People's First Exhibit 1. I believe it's been admitted by stipulation at this point.
Exhibit 1, if I haven't said so,
Thank you. May I publish? And just for the record, I put up People's Exhibit 1 just before I start playing this. Sir, do you recognize this still frame?
I do recognize this.
And is this the video that you took depicting what happened that day? All right. I'm going to play People's Exhibit 1. It's a video about 19 seconds long. There should be audio to go along with it. Hold, please.
No, help! Help! Stop it! Stop it!
If we can take, perfect, thank you. No further questions, thank you.
Cross-examination.
Thank you, Your Honor.
Well, Mr. Bucknam, my name is Natalie Pate. I'm an attorney for Mr. Skinner. I just have some questions to ask you to follow up on your testimony that you given to the court today, if that's okay. If at any time you either don't hear my questions or frankly they don't make sense or you just need me to repeat it for whatever reason, let me know and I'm more than happy to do so. So at the time of this incident in April, you were an employee of the Rocket? And that's like a gift toy store, right? And do you still currently work there? And how long have you worked there?
14 years.
14 years. And you testified that you were on your way to the post office at this time, correct?
Correct.
And I believe you testified that it was like a dolly you had your packages on, right?
I have a marketing package on the dog and smaller packages in the blue right here.
And is this dolly, is this something you like pull, for lack of a better term, with a handle behind you? And how large would you say that cart is?
It's a retractable cart, and when extended, it's about 4 feet high.
Okay, thank you. And so when you were walking with your packages on your way to the post office, you bumped into Mr. Skinner with your cart, correct? At one point, however, he did turn around and tell you something to the effect of, you could have said, "Excuse me," correct?
He did.
And some sort of verbal altercation ensued. And this was right outside of the beer cooler in Ypsilanti, correct?
Altercation was inside the tap.
Inside the tap room?
So started outside the Broadfield property and continued outside the tap.
So we obviously all just saw the video that we watched, and you took this on your cell phone, correct? And you'd agree with me that Mr. Skinner is walking away from you in that video, correct?
In the video, yes.
And you'd also agree with me that the video depicts you continuing to follow him while filming, correct?
Correct.
And this video does not depict Mr. Skinner following you?
It does not.
And you would also agree with me that Mr. Skinner, we did see in the video that he did hold up a screwdriver, correct? You'd agree with me that at no point did he walk towards you while having that screwdriver in his hand, correct?
He turned around, but did not walk towards me with it.
Thank you. So just a couple other questions, Mr. Bucknam. I may have missed it when you were testifying about how the screwdriver came into play, and maybe honestly, I'm just a little bit confused. So how I understand it, there was a verbal altercation and then some sort of tussle. Where did the screwdriver come from?
He must have had it on his person.
Did you see it at any time before this altercation? And during the verbal altercation in this mutual tussle, did he at any point take out the screwdriver if he had it on him? So you testified today that Mr. Skinner threatened you or threatened to shoot you. Did you at all any time see him with a gun? When he made these verbal threats, did he present any sort of weapon? Did he present any sort of object at all when he made these threats? Did he even have anything in his hands? Thank you, Your Honor. No further questions for this witness.
Any redirect?
No, Your Honor, thank you.
All right, thank you. Sir, you may step down.
Your Honor, the people have no further witnesses and would rest at this time.
Any witnesses for the defense?
No, Your Honor.
Do you have a motion?
Your Honor, people would move for bind over on count 1, felonious assault with count 2 to follow. I believe the evidence the court heard was that the victim was walking down the street just doing his job. When he passed by the defendant became agitated at him and then proceeded to punch him. I believe the testimony was about 20 times, getting the victim on the ground. While the defendant was fleeing from that assault, the victim recorded him, and the defendant, as the court saw, raised a screwdriver at him and said, "I'm going to stab you." He raised it in a threatening manner. Believe that the evidence shows by a probable cause standard that an assault occurred where the victim did state that he was afraid.
Well, why would that be an assault?
Sea views for days. Oh, and when I tell you the Virgin Voyages food is absolutely unreal, and it's all included. This has been truly amazing. But next time, you really need to be here.
On this individual. Why, I'm talking specifically about the felonious assault.
Because the screwdriver, I believe, is a deadly weapon that satisfies that element, as opposed to why it's an assault. That's because he raises it, threatens him. I believe the victim testified that he was afraid that he was going to get stabbed, and he said as much, and that's why he stopped following him. So I believe that shows that he had that apprehension of an immediate battery.
I get that, but at the same time, the physical altercation which occurred on the ground with the 20 punches to the face, that has transpired. As I understand the witness, they then testified that that attack is over.
Correct.
The defendant, according to the testimony of the witness, then is leaving the scene.
Yes.
The witness then follows that.
Correct.
And is in essence saying, "Leave me alone."
The defendant is making statement, yes, I want to.
Yeah, and says what he's going to then do.
Yes.
So at that point, why is that an assault? Why he is retreating from, assuming given the testimony occurred, a bad act has occurred. He is then leaving from that bad act.
Yes.
He's then followed by Mr. Buckram.
Yes.
And then turns, and that's when he says something.
Yes, and the people's argument is when he makes that turn.
Go ahead.
When he makes that turn and makes that statement, I believe the video showed him raise his arm and lift the screwdriver in a threatening manner. And given that motion and the victim's statement that he stopped following because.
But why would that be an assault by him?
Because he's making the victim fear an immediate battery.
But only because Mr. Bucknam is following.
Yeah.
That's the only reason that portion of the altercation occurs is because Mr. Buckman goes after him.
Yes, and I believe the victim testified the reason he was recording was in order to get the defendant's identity due to that assault. He was trying to make sure that this could be responded to. I don't believe that following a defendant gives that defendant the right to then threaten that individual with a screwdriver, especially in an area that's open to the public and there's no reasonable expectation of privacy.
I don't know where the privacy issue comes in, but okay, all right. Response.
Your Honor, I would object to the bind over on the count of assault with a dangerous weapon. I would argue, Your Honor, that there was no assault with a dangerous weapon or the screwdriver. The complaining witness did testify that Mr. Skinner at no time stepped towards him while the screwdriver was in his hand. Obviously, we all saw the video and that Mr. Skinner did raise his hand up while holding a screwdriver while he was being followed. He made no movement and did not put the complaining witness in a position of a reasonable fear of a battery. Given the nature of the weapon also being a screwdriver, to be candid, it's not a gun. Without any movement towards the complainant, my client would not have been able to assault him with a dangerous weapon. That being said, Your Honor, I would object to the bind over, and I do believe even by a problem.
Well, he wouldn't have to necessarily make a movement. He would just have to have the ability to come into contact. Which if he had run in the direction that the camera was pointing, he could have done that.
Absolutely, Your Honor. If he had run that way or chose to flail that object in his direction. But of course, that's not the situation we have here. Mr. Skinner, there was some sort of fight. I won't dig into that. Mr. Skinner was walking away from it. He had an object in his hand. He was being followed. He turned around and told the complainant whatever he said. And I would argue that the people did not meet their burden even by a probable cause standard and object to the bind over on this felony charge, Your Honor.
Anything additional from the people?
No, Your Honor.
In this case, the court listening to testimony of Mr. Button, and I think it's important to face the court's distinction as to what transpired based upon the testimony of Mr. Button. There was first this assault, which occurs where he's indicating that he's punched 20 times. At some point, he's on the ground, but he then gets himself up and the defendant is up at that point in time. The defendant, strangely enough, begins, and I'll call it a retreat. He basically begins to retreat. It is then Mr. Bucknam that is continuing. He may have his justification for what he's doing, but he's continuing the potential altercation as he's following it. It is at that point, and remember Mr. Bucknam's testimony is that he doesn't see the screwdriver. The screwdriver, he's only presuming that it's on his person. Don't know that, but he's presuming it's on his person at the time of the initial assault. But the defendant is leaving. He's following for the purposes of identification. The threat, there is no longer a threat to Mr. Buckman, other than the one that he is then creating. The defendant turns around, says what he's going to say, raises a weapon. Because of that time frame, the defendant, while he may not have acted right, at the moment that is happening, he is not acting unlawfully in what he's doing and would be entitled to be there and potentially defend himself from what may be an oncoming assault of Mr. Buckman. Maybe, I don't know. So for those reasons, and the court looking at these as two very distinct acts, as I listened to the testimony of Mr. Buckman, the court is going to decline to bind over the defendant on the assault with the dangerous weapon finding that at the moment that weapon is exposed, it's not an assault with a dangerous weapon. It could be a number of different things, but it's not an assault with a dangerous weapon. And we'll remand it on the aggravated assault to 14A2.
Thank you, Your Honor.
I will set pretrial on count 2.
September 24th.
September 24th, 2025, 10 a.m.
Yes.
10 a.m. before Judge Barf. Found with its conditions will continue. Court does call the cases of the people versus Tyler Meddy.
Morning, Your Honor. Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Meddy, who's approaching. Mr. Meddy, would you state your name for the record, please?
Tyler Meddy. All right.
And it's date and time set for preliminary examinations on both matters. We have reached a resolution subject to the court's approval.
I have in the case ending in 1463, a plea form that indicates that the defendant would be pleading to retail fraud in the second degree, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. In the other matter, 15th District Court case, it's also the defendant would be pleading to an added count 2, retail fraud second degree, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Yes, Your Honor.
All right. May I have him sworn?
Right. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Tyler Meddy.
All right. Sir, it is this court's understanding that you're going to plead to 2 charges of retail fraud in the second degree. Is that correct?
Yes, sir.
Those are misdemeanors carrying a maximum penalty of up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, in the 15th District Court matter, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead guilty to these charges?
It would be too much more if he would sentence me. It would be doing too much.
You don't want to do that.
I understand.
All right. Do you still wish to plead guilty?
Yes, sir.
To the charge of retail fraud second degree occurring in Pittsfield Township contained in case ending in 1463, how do you plead?
Guilty.
To that same charge as contained in the case ending in 5714 occurring in the city of Ann Arbor, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
On probation.
Were you on probation at the time of these offenses?
I was not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
Starting in case 1463, on the date of May 8, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Lowe's store that makes you think that you're guilty?
I stole a couple power tools and walked out the door.
All right. So you went in there, stole the power tools, or took the power tools, tried to walk out of the store without paying for them?
I did walk out the store.
All right. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
I did not.
And this property you took, it was property that was offered for sale by Lowe's? In the other matter, on the date of October 25th, 2024, at the location of 700 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do at the Macy's that makes you think that you're guilty?
I tried to steal some merchandise that was not mine.
Okay, you went into the store,
Yes,
took some merchandise, tried to walk out of the store without paying for it.
yes,
The store was open to the public at the time.
it was.
You didn't have anybody's permission to take that property, did you?
I did not.
And this was property that was off of sale by Macy's?
Yes,
And these, please to the second, are they based upon prior or value?
Value, Your Honor.
All right. So going back to the Lowe's transaction, was the amount of property that you walked out of the store with, was that greater than $200?
yes,
And likewise with the situation regarding Macy's, and your activities there, was the value of the property that you walked out with greater than $200?
it was.
All right. Sir, you understand that if I accept your pleas on these cases and you commit misconduct as defined by the Michigan court rule from the time I accept a plea to the time of your sentence, that you would not be entitled to any sentence the court would no longer be bound by any sentence evaluation regarding this case, and you would not be entitled to withdraw your plea. You understand that?
I understand.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None that I'm aware of, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to these two charges, retail fraud in second degree, which is count 2 in each case. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A probation as well as 15th District Court probation. Sentencing in the case ending in 1463 will occur
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. That is before me. And that matter is bound will continue. In the other matter, sentencing will occur
October 21st at 9 a.m.
October 21st, 2025, 9 a.m. before Judge Vallow. Bound in that case will continue. All right. Thank you.
Thank you, Your Honor.
Yes, on Thursday last week.
We didn't do anything. Court does call the case People versus Ashley Nader.
Alexander on behalf of the people, Your Honor.
Morning, Honor. Rob Chico on behalf of Ms. Nader, who's approached Ashley, state your name.
Ashley Nader.
All right. I have before me a plea form that indicates that the defendant would be pleading to an added count to stalking the misdemeanor charge, a 1-year offense and up to a 5-year probation offense. And upon our successful plea to that charge, count 1 would be dismissed.
That's correct, John.
All right. Ever sworn?
Raise your right hands. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Help you God.
I do. Ashley.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of stalking.
Yeah.
That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years probation. You understand that?
Yeah.
You understand also that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Freshour in the 14A4 District Court. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yeah. Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
I thought it was here and it's not.
That's why I like.
Between the dates of July 1st, 2025 and July 8th, 2025, at the location of 7827 Sandy Beach Drive, Northfield Township, Washtenaw County, State of Michigan, what did you do regarding a Dustin Stroud that makes you think that you're guilty?
I was calling and texting when he didn't want me to.
Okay, you kept calling and texting. At some point during that process, approximately how many times did you try to make contact?
I have no idea.
More than 2?
Yeah. Few.
And had this individual told you not to contact them?
Yes.
And made that clear
Yes.
to you? And after that, you continued to contact that individual?
Yes.
All right. Ma'am, I have to indicate to you that between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any evaluation. The court would no longer be bound by any evaluation or recommendation regarding your case, your sentencing in your case. You understand that, ma'am?
Yes.
And you would not be entitled to withdraw your plea.
Okay.
Counsel, have I complied?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this?
I gotta get, yes, I gotta get there.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1484. Probation sentencing in this matter will be
Don't worry about that.
October 28th, 2025, 9 a.m. before Judge Freshow.
Judge, yes, Judge, a couple issues.
Yes.
One being the tether. She's been on tether probably since mid-July. There have been no violations. I would ask, and quite frankly, Judge, I've told her, you've told her, if there's any attempt to call this young man, that she wrecks her deal with the court. I would just ask the court that no need for any, the tether. Hold on. And the second issue, Judge, is the sober link. Now, there's a report and there's numerous quote unquote mistests, but she works very odd hours. She has sleeping issues, which she's consulted with a doctor. To her credit, every time she's missed a test, she's always gone the very next day or within a couple hours. So there's absolutely no evidence of her drinking since July. We would ask the court if it would remove the sober link and the tether.
Well, the problem with the tether is she took off to Tennessee.
Judge, that was, she learned her lesson, Judge, on that. I would ask if you would please consider that. She's a hard-working lady. It doesn't interfere with her work. She's learned her lesson. She's not going to contact
Hold
anybody.
on. I have quarrels with that. She takes off to Tennessee. She comes back to court. We get after her about taking off to Tennessee and everything else. And then she doesn't test properly on the SoberLink device. Now, it would seem to me that if somebody were that close to violating it, be remanded to jail until the conclusion of the case, and she kind of escapes that she would follow to a T the instructions of the court regarding her bond.
Judge,
she didn't do that to the extent
I can't listen to both of you.
that I had to send an order out directing her compliance again with the SoberLink, which we sent out on Thursday.
I know.
She said she never got the order. That's not the issue.
Oh, I can give you a copy. It was sent out on Thursday when we received it, but you've been missing tests all over.
Judge,
she's not been anything from the people.
I would object to the removal of either tether, as the court stated she did reinstate earlier. I do also have concerns that we did put the sober rate because the videos that came about or with the Crown bottle. So I mean, I have concerns that she can't follow her bond. So at this point, I would ask they remain as set and it can be addressed as sentencing, but she needs to become a private provider.
Judge, the only thing I would, and I just want to reinforce this, and for what it's worth, any missed test within an hour or two or shortly with another test was taken that showed no evidence of alcohol. I understand she missed her test, but to her credit, there was no evidence of alcohol.
I don't think she listens to really what the court is saying and just skates on the edge, quite frankly, Mr. Killawall.
Yeah.
I think the court very clearly told her she was not to leave the state of Michigan. And we have to, without the GPS tether, we wouldn't have known, but she's somewhere down in Tennessee. Then she gets back here. There's an admonishment regarding that. She's got instructions as to what she has to do, and she fails to follow it. She just continues to not blow when she's supposed to blow.
Okay.
And there are windows that she has to do it. It's not like she's got to do it right at that point in time, and she just doesn't do it. I don't think she pays attention to what the court's telling her. And I think, quite frankly, I'm just gonna dare you to do that before Judge Freshour, because I don't think she's gonna tolerate any of this at all. Motion for bond reduction or any change in bond is denied. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people of the state of Michigan. You gotta get him out. Need to do something about Ann. I don't feel safe. No, yes, you can go home. But only if I tase you. Court does call the case of the people versus William Bastable.
Good afternoon, or sorry, still morning. Good morning, I'm Raymond Cook with the people.
Come up here first, William.
Alex Warren Green on behalf of Mr. Bastable. Mr. Bastable, can you state your name for the court?
William Bastable.
Terms of the date time set for preliminary examination, people are ready to proceed.
The defense is ready to proceed, Your Honor.
I would like to just put for the record, there was an offer that was extended because this exam is being held. That offer is no longer held open and having to negotiate up.
What was the offer?
The original offer was that he would waive up on this. He has another felony at R&O pending. He was going to plead to that one. This would get dismissed at the time of the plea in circuit court. That's no longer being extended.
All right.
And Your Honor, I relayed that to my client. We discussed it at length. His decision is to, at this time, reject that offer and continue with preliminary examination. I think he knows that the people are rescinding their offer based on his decision.
Is that correct, sir?
Yes, sir.
All right, have a seat.
People call Sergeant Shana Thompson.
Come forward and be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth and whole truth? Thank you for your first and last name for the record, please.
Shana Thompson, SHANATHOMPSON.
You may inquire.
Thank you. Good morning, Sergeant. How are you employed?
By the Eastern Michigan University.
In what capacity are you employed?
I'm a sergeant,
How long have you been with the EMU Police Department?
18.
18 years. And were you employed as such on August 10th of 2025?
Yes, sir.
What were you doing at approximately 5 p.m. that day?
At 5 p.m., I was patrolling in the city of Ypsilanti. I was in full police uniform in a fully marked.
Did you have contact with an individual by the name of William Bastable on that day?
Yes, I did.
Do you see that individual in the courtroom here today?
Yes.
Can you please point to him and identify him by an article of clothing that he's wearing?
He's the defendant on the table in a shirt.
Your Honor, if the record may reflect that the witness has identified the defendant.
Record shall so reflect without objection.
Thank you. What initially made you contact the defendant on that day?
Well, I was in the area of 414 Emmett Street, the city of Ypsilanti, in Washington County, and I saw the defendant, Mr. Bastable, on the side of the house, and he was crouched over, sitting on the ground, facing the porch, and kind of the corner of the porch on the side of the house. And it's a suspected drug area. I know that it's suspected. So I saw the defendant sitting, and it looked like he was crouched in a position where it looked like one of his arms was crossed over the other, and I suspected drugs.
And you said you're at 414 Emmett Street. What's at that location?
It's a house, multiple residential, broken up in different apartments.
And you said that you saw the defendant outside or inside that house?
Outside on the ground, outside the porch.
Okay. Were you able to make contact with the defendant?
Yes.
How did you make contact with him initially?
Well, I pulled up, there's an alleyway along the side of the house. I was in contact with him, we stepped out of my car, and he hadn't turned around yet, and I said, hey.
What was going through your head at the time that you first made contact with the defendant?
Well, I thought that he was preparing and using drugs.
Okay. How far away were you when you first made contact with the defendant?
10, 15 feet.
All right. And did he ever respond in any way?
He stood up and turned around and said, you know, like, hey, what's going on? What are you doing here? And I think I immediately confronted him and said, you know, hey, are you shooting up here? And he immediately denied that.
Did you observe anything that would be consistent with using drugs at that time?
Yes, I saw the cap to a syringe up on top of the porch, and on the ground was a syringe, which when on further inspection, it had not been used yet. It was laying on the ground right where Mr. Basketball was, and there was a small tinfoil container which would be used to put the drugs in.
What did you do after you were able to make that contact with the defendant?
I confronted him and said, I think that you were using drugs. At one point, when I said that he was and he denied it, he made an involuntary response and he actually touched his pocket, which made me believe that he had some type of narcotics on him in his pocket.
What did you do next?
We chatted a little bit. I again confronted him and pointed out the syringe. I actually walked over to it, pointed those out to him, and I asked him for his name. He refused to give me his name. He told me that he wasn't doing anything illegal.
At some point, did you try and arrest or detain the defendant?
Yes, so I asked him to put his bags down and I told him that I was going to detain him.
Sorry.
Oh, no, he said that he wasn't doing anything wrong, and I grabbed his arm, and I got a handcuff on his arm, and then he started pulling away from me, and I held onto the handcuff as we were struggling. I told him, hey, if you run from me, I'm going to tase you, and he was able to break free from my grasp.
So let's rewind back to the beginning here a little bit. So you inform him that you're detaining him, correct? And did you handcuff him before or after you informed him of that?
After.
And were you able to get the handcuffs on completely?
I was able to get one handcuff on his right arm.
And at that point, you said,
Yes, his right arm.
at that point, you said he started pulling away. Did I hear you correctly?
Yep.
When you say pulling away, is this like a full body pull away? Is he just pulling with his arm? How is he pulling away?
So if you can picture it, the handcuff is on his arm. I have my hand around the chain, pulling between the two handcuffs, and I'm pulling onto him as hard as I can, and he is pulling away from me and walking away as hard as he possibly can.
And just for the record, it looks like you're sort of leaning backward.
Yes.
You're pulling back with your
Yeah,
whole
I'm
body.
moving backwards, and he's, pulling as he's walking away.
What orders, if any, were you giving him while he was pulling away from you?
I was telling him to stop. I told him that I was going to tase him. At one point, he reached over and grabbed my arm while I still had it.
After you told him that you were going to tase him, what did he do then? And when I say he, I mean the defendant.
Yeah, Mr. Bestable was able to break free from my grip. He tripped and he fell, and then I deployed my department issued taser.
Were you successful in deploying that taser?
I was. Not to get too much into it, it did get immediate neuromuscular incapacitation, so that means 2 probes struck his body. I'm a taser instructor, so when I realized it looks like I got like a good connection enough to knock him down, but then when he was on the ground, it must have been some type of one probe was maybe in his skin, and the other one was possibly attached to his shirt. So it got it didn't have total connection, so it was a capacitating at first, and then it was just kind of a pain compliance as the probe went in and out of struggling.
Gotcha. And what made you decide that you needed to use your taser in that moment?
Well, that moment I told, because he was fleeing from me, and he had already broke free from my grip, so just he was fleeing from me.
When he broke free from your grip, the one handcuff that you got on him, was that still on him, or was he able to slip out of it?
No, that was still on.
Okay.
And actually was able to, at some point in the struggle, when I was still holding on, I clasped it down further on his arm.
Okay. So you deploy your taser, get some amount of success. What happens then?
He gets up, and I deployed 2 more probes, and this time I believe both probes hit him for a full muscular incapacitation for a full 5 seconds. While he was on the ground, he was laying perpendicular to me, and I could see that the way he was laying, he kept reaching across his body, so if you're me and I'm facing kind of away, I can see that he's now reaching back toward that right-hand pocket. And I didn't get it out enough, but I remember saying, don't, because I was thinking, don't reach for whatever you're reaching for. And at that point now, I've heightened my awareness. I'm thinking, is Mr. Batchel reaching for a weapon that I can't see? He gets up again once the 5-second cycle has continued. And as he gets up, he is still kind of turning away from me. And I'm thinking, well, I can't see right hand side. I don't know if he's reaching for a weapon. So I re-energized the taser again for a third cycle, and he fell to the ground.
So at this point, you had to use or deploy the taser. You deployed the taser twice, but did 3 cycles. Am I understanding that correctly?
Yes.
Okay. After that third cycle, what happened then?
He was sitting on the ground with his legs up in front of him, his butt up and his hands up, and I'm like, don't move, stop moving. And I came down, crouched behind him, grabbed the handcuff, and started to pull it around behind his back. He was able to get onto his feet and started running, tried to deploy a taser again, but they, at this point, the probes were not connected because there was sometimes probes can become disconnected.
So he runs away from you even after being tased 3 times now?
Yes.
And I don't know if we clarified, but when you were able to successfully use the taser those 3 times, how far away were you from the defendant at those times?
I would say during the course of the 3 times, anywhere from 10 to 5 feet from him.
Okay. After he starts running away, what happens then?
He was ultimately able to stand so he get away. The officers flooded the area. We went down Hammond Street, jumped a fence through some backyards, and
Did you follow him or?
I followed him and tried to catch him, but
Were you following him on foot in your patrol car? How were you following him? On foot? Was anyone else there with you when all of this was happening?
there were no one else.
So you were on your own, you didn't have a partner or anything like that? Okay. You said at some point he jumped a fence. When did that happen?
We ended up going westbound toward Ballard Street, and then he ran south on Ballard and then ended up back on Emmett Street. There's a multi apartment complex. He ran back behind that. And, I said jump the fence. He was able to shimmy through a fence.
Okay, so he didn't go over a fence, he got through a fence.
And I presume once he got through that, I couldn't see, but there was another fence, so I don't know if it was intact, and then I ended up finding his shirt on the other side of the fence, so at some point I jumped the fence.
Okay. One moment, please, Your Honor. Nothing else, thank you.
Good morning, Sergeant. My name is Alex Warren Green. I represent Mr. Bastable in this matter. Sergeant, in your direct examination, you told us that you were aware of recent drug activity at this location, right? You never saw Mr. Bastable using drugs there, did you? And you talked about observing a syringe cap, a tin foil container, and a syringe itself, right? And you didn't see Mr. Bastable with those things in his possession, right? He wasn't holding them, was he?
He was.
Okay. And they were on the floor of the porch that he was next to, correct?
So the tab was on the floor of the porch, but the syringe and the
Okay. And when you say this was an area where recent drug activity had occurred, that's based on your information regarding other incidents not involving Mr. Bastable, correct? Okay. You didn't see any narcotics or suspected narcotics during this interaction, did you? And when you approached him, he did not identify himself, is that correct?
He did.
And so you didn't know his name? You were not aware of any warrants at that time, were you? Okay, so you told him he was being detained, right? And then he ran and you tased him, correct? And he got away.
Yes.
So he left his backpack at the scene, is that correct?
He did.
And you searched the backpack? You didn't find any drugs, did you? You didn't find any paraphernalia, did you?
No.
You didn't find any guns or weapons of any kind in that backpack, did you?
No.
Okay. And when Mr. Bastable was apprehended, you were not the officer who made the arrest at that time, were you? Okay. Your Honor, I have nothing further at this time. Thank you.
You redirect.
When you say that the syringe, I believe you said the syringe and like the tinfoil was right at the defendant's feet. When you say right at the defendant's feet, how far are we talking?
Like you would have crouched over.
Okay. No further questions. Thank you.
And at the point in time, I think you were testifying, he
Currently, we have no further witnesses in the rest of this time.
Any witnesses for the defense?
None from the defense, Your Honor, we would rest.
Do I have a motion?
People move for binder on count one for resisting and obstructing officer. I believe the evidence has shown that Sergeant Thompson was working with the police department on August 10th of this year in Ypsilanti. She observed the defendant engaging what she believed to be a criminal activity using controlled substances. When she tried to investigate that and tried to detain the defendant, he pulled away, ran, had to be tased multiple times. Ultimately, he was successful in fleeing from Sergeant Thompson after orders to stop and orders that he was under detention or that he was being detained, believing that the burden by probable cause standards to find over.
Your Honor, the defense would object bind over for the record in making the bind over determination, correct? Okay. You didn't see any narcotics or suspected narcotics during this interaction, did you? And when you approached him, he did not identify himself, is that correct?
He did not.
And so you didn't know his name? You were not aware of any warrants at that time, were you? Okay, so you told him he was being detained, right? And then he ran and you tased him, correct? And he got away.
Yes.
So he left his backpack at the scene, is that correct?
He did.
And you searched the backpack? You didn't find any drugs, did you? You didn't find any paraphernalia, did you?
No.
You didn't find any guns or weapons of any kind in that backpack, did you?
No.
Okay. And when Mr. Bastable was apprehended, you were not the officer who made the arrest at that time, were you? Okay. Your Honor, I have nothing further at this time. Thank you.
You redirect.
When you say that the syringe, I believe you said the syringe and like the tinfoil was right at the defendant's feet. When you say right at the defendant's feet, how far are we talking?
Like you would have crouched over.
Okay. No further questions. Thank you.
And at the point in time, I think you were testifying, he
Currently, we have no further witnesses in the rest of this time.
Any witnesses for the defense?
None from the defense, Your Honor, we would rest.
Do I have a motion?
People move for bind over on count one, resisting and obstructing. Officer, I believe the evidence has shown that Sergeant Thompson was working with the Eaton Police Department on August 10th of this year in Ypsilanti. She observed the defendant engaging what she believed to be a criminal activity using controlled substances. When she tried to investigate that and tried to detain the defendant, he pulled away, ran, had to be tased multiple times. Ultimately, he was successful in fleeing from Sergeant Thompson after orders to stop and orders that he was under detention or that he was being detained, believing that the burden by probable cause standard to find over.
Your Honor, the defense would object to bind over for the record. In making the bind over determination, we would ask the court to consider the Michigan Supreme Court's recent holding in People v. Prude, Prude, that's 513 Mich 377, 2000.
And I believe, well, in that case, where we're going to start with Matthews or?
Whatever the court prefers, Your Honor, we can do it that way.
Well, let's do this. Let's get her done.
Thank you.
All right. And this is actually, Ms. Eckenrudey, you are calling the complainant.
That is correct, Your Honor.
All right, very good. If she can,
Your Honor, for the record, we have an objection to that. Mrs. Burns has already testified at length. She's answered many questions. I've asked the defense for an offer of proof of what they would need to call her for after having cross-examined her for quite some time. And I'll let defense counsel speak to that. But my understanding is there may be some questions based on the testimony of other witnesses. I would ask that, well, first I have an objection to her being recalled, but if the court declined to recall her or allow for her recall, I'd ask that the questions be limited to whatever new information we have based on the testimony of particular witnesses and not to rehash essentially her former testimony.
and as I had indicated, counsel, I'm not going to let the latter happen. But there were witnesses that testified after she did. My understanding, Ms. Eckenrudey, is questions are directed toward issues raised with witnesses.
Yes, Your Honor. So there are questions that I needed to ask this particular witness as follow-up based on some of the testimony that was brought out by the other witnesses. And honestly, Your Honor, there are some, I mean, in communicating with my client, there are some other questions that he wanted for me to ask this particular witness.
And Your Honor, I guess if I may.
Where the opportunity has already been given.
Your Honor, that's a difficult question to answer, primarily because, I mean, that was one of the reasons that I reserved the right to recall her, because I knew that there were some points that, depending on how the remainder of the testimony came out, I may want to bring up. If there were testimony that was not able to come out from other witnesses, then she's the only person that would be able to testify to that. I may not have asked her those questions on cross immediately, or maybe there were questions that were not brought up in direct that just wouldn't work in the course of my cross that I would have to bring up again through my direct.
All right, well, rather than go through this almost in a hypothetical, what I will do is where there's an objection, make the objection and I'll rule as we go forth. My intent, quite frankly, is not to allow the rehashing of what she's already testified to.
Thank you, Your Honor. And the other matter I want to put on the record, we briefly discussed before we finished last time, and my understanding is we are not going to be asking questions or going into anything that was found on the defendant's phone as a result of that search warrant. During my questioning of Sergeant Matthews, I was objected to, I was stopped. We didn't get into any of that, so that would be another limitation I want to make sure we have on the record.
Second, early.
And Your Honor, I do understand that we are not going to discuss, or I do not plan on discussing anything that was a product of the search warrant from Mr. Burns's phone.
Okay, very good. All right, you may call your witness.
Your Honor, defense calls Madison Burns to stand.
Just want to make sure that's. Ma'am, please come forward. May I have her sworn?
Please take a seat, raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. See? State and spell your first and last name for the record.
Madison Burns, ISYN.
All right, you may inquire.
Thank you, Your Honor. Hi, Madison. I think you remember our last conversation. I just have a few more questions that I need to ask you, okay? Madison, I just want to take you back to, I think this was on May the 9th, when you were at the hospital at U of M. Do you recall being in a room? Your Honor, I want to ask the court if it's okay that I ask cross-examination questions rather than direct. Thank you, Your Honor. You were in a room across the hall from the room where your son was being treated. Is that correct? It was around the corner. Okay. And you went into that room with a nurse? Okay. And when you went into that room with the nurse left you in the room, right, by yourself? Okay. And then after you were left in the room, the social worker came in to speak with you. Okay. But at no point, you had not met that social worker previously, is that correct? Do you remember the social worker's name? And do you remember telling the social worker what had happened between you and my client, your husband, Mr. Burns? Okay. And do you recall what day you told her that incident had happened? You told her it was on May the 7th. You know, she took notes as to your conversation with her? Okay. You talked to the social worker about a safety plan. Do you recall that? You don't remember? Do you know anything about a safety plan?
And I'm gonna object if we could be a little more specific.
I'll sustain that objection because that means a lot of different
Okay.
things.
All right, that's fair. Okay, so you had told the social worker that you and my client had had sex. You're saying that you told her that it happened on the 7th. Okay. Do you know why she would have thought that it happened on the 8th? Okay. And when you told her that you and your husband had had sex on that date, do you recall anything else that you told her? Now, I want to talk to you a little bit about that date on the 10th. Do you remember you and Jerome talking about posting a photo of his vehicle on Facebook?
I'm gonna object, Your Honor. I'm not sure how this is relevant.
Your Honor, if I can just have a little bit of leeway, this leads to some of the testimony that was given by Officer Eckel. No, that's not his name. The arresting officer, Judge, I had asked him some questions in regards to statements that my client had made. Aaron.
I'll overrule the objection. I'll allow you.
Thank you, Your Honor.
Go ahead.
Okay, I didn't hear your answer to that question, Madison, I'm sorry. Do you recall you and Jerome were looking to post his vehicle on Facebook Marketplace for sale? You remember that? Okay. Okay. He wanted to post his vehicle for sale on your marketplace. Okay, so when you, and how was he gonna do that? He was gonna use your phone to do that, is that right? Okay, so you had opened your phone for him to allow him to make the post? You had your Facebook on there, okay. So while he was doing that, do you recall realizing that he saw some messages between you and someone that you were involved with? You don't remember? But you had been having a relationship with someone else, is that correct?
Sustained.
On that day, you don't recall giving, you didn't give my client permission to go through your messages on your phone. But you had previously indicated that my client accused you of cheating on him, right?
And I'm gonna object. We're getting into kind of old things, but also I know there was some leeway for leading questions, but now we're getting into a very a more aggressive form of it, and I don't think that's necessary to develop the testimony.
I'm gonna sustain the objection a lot and ask you to rephrase in a second.
Okay, thank you. Madison, on that day, had Jerome accused you of cheating on him? Okay. And then Madison, let me just take you back to the 7th, okay? You had previously testified that my client had been asking you over and over again to have sex, is that right? Okay, and then when you did decide to have sex, you walked into that bathroom first, right?
I'm gonna object, Your Honor.
I'm gonna sustain that.
One second, Your Honor.
Bless you. You want to get the microphone.
Thank you.
Bless you. Bless you. One more time, you're on your own.
Okay, Your Honor, I do not think I have any further questions for this witness.
Any cross.
Very briefly, Your Honor. Hi, Madison. Madison, you seem to have some trouble remembering today. How do you feel about being here again to testify? Thank you. Nothing further on.
And Madison, welcome to my life. All right. Okay. You may step down.
Your Honor, well, I guess it's not my witness. I shouldn't.
Pardon?
I guess, can she be excused, Your Honor?
Yes, I don't have any further questions.
This witness is excused. Okay, before you call your next one, I have to try to be fair to everybody. I did this that way. Mr. Killawall, do you have someplace that you have to be, correct?
Judge Conkey?
Judges are patient, no way.
What if I said the president?
What?
The president of the United States.
And you're definitely gonna wait. Let's take Mr. Burns back. I'm gonna try to get one more out and something short. Get folks moving and then we'll call it back up. Okay.
I'll be.
That's kilowatts. That's- Yes. Yeah.
Did you take any?
No. Yeah.
I meant that I needed to see. Okay.
And whenever they were out swimming.
I did tell.
Okay. Court does call the case People versus Brandon Fleming.
Annalise does on behalf of the people, Your Honor.
Your name, sir?
Brandon Fleming.
All right. We ready to proceed?
Yes, Your Honor. People are ready to proceed.
All right, you may call your first witness.
Thank you, Your Honor. People will call Lucinda Print up to the stand.
Ma'am, please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State spell your first and last name for the record.
Lucinda Print up. Print.
May inquire.
Thank you, Your Honor. Good afternoon, Lucinda. Lucinda, do you know a Brandon Fleming? How do you know him? Okay. And if you saw Brandon today, would you recognize him?
Yeah.
And is he in the courtroom right now?
Yeah.
Can you briefly identify something he's wearing and where he's sitting? And at the defense, is that where you pointed? Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
With that objection, record so reflect.
Thank you, Your Honor. So Lucinda, I'm going to direct your attention to August 4th of 2025. On that date, were you at a 2380 Carpenter Road?
Yes.
And is that in Ann Arbor, Michigan, County of Washtenaw? Okay. And on that date and at that location, did you come into contact with the police?
Yes.
Why did you come into contact with the police?
They were dispatched because there was a suicide.
And did you make that call?
No.
Okay. And after you first came into contact with the police, did you report anything that happened that day?
Yeah.
What did you report to them? What happened?
I told them that prior to them arriving, to the thing that I had.
And who's him? And why did you have him removed?
Because we were arguing.
And did you report anything else happening during that argument?
Yes.
What did you report happening?
That he put his hands on me.
And when you say he put his hands on you, how did he put his hands on you during that argument? He choked you. So when you say he choked you, how did he do it? With one hand, two hands? Okay. And did he put them around your neck?
Yes.
And could you breathe?
No.
And that argument that you're referring to, how did that argument start?
The argument started because he accused me of cheating on him.
And after he accused you of cheating, how did it progress from there?
Kind of upset because I had previously took my phone charger, so I wasn't able to charge my phone. And I called a friend to bring me a charger, and they came into the store to bring me a charger, and
Okay. And that's when it became physical?
yes.
Did he do anything else? And when you say someone contacted police, who was the one that contacted police?
Well, the police told me that he was going to contact me.
And he is Brandon?
Yeah.
Okay. And did anything else happen after that original argument? What happened?
And asked me if I wanted to get breakfast. And so we went down there to get breakfast, but I guess I was taking too long, so we came down there to get me. And on our way back,
We started arguing again, and he started shooting and cheating, and we were walking in the door, he like nudged me with me, I fell and dropped off.
And when you say nudged you with his knee, what do you mean? How did he do that?
I was walking in the door, his knee and he.
Okay, where did he knee you? Okay. And Your Honor, can I have one moment?
You may.
Thank you. Nothing further for this witness from the people, Your
All
Honor.
right, very good. Cross-examination.
Listen, my name's Bob Kilwald and I represent Brandon. I'd like to ask you some follow-up questions. You said you were in a relationship with Brandon. How long were you in that relationship for?
For about 5 months.
Okay. Do you also have a child from him with a previous relationship?
Yes. I'm pregnant.
Okay, but is there another child also involved? No? So okay, so you're pregnant and you believe it's his child?
Yes.
Okay. On August 4th, you said you were at 2380 Carpenter Road. What is that? What's the name of the hotel? Okay, and were you staying there with Brandon at the time?
Yes.
So, okay, so when did you first go to the Days Inn? Okay, so you were there, it's my understanding you were waiting for housing?
Yeah.
And so how long had Brandon staying with you at that time? I mean, did you move in together?
He just came there.
Okay, he was invited in, correct?
Yeah.
Okay. And so there was an argument, you said there was an argument. Was the argument over the length of time it took for you to go and get a phone charger?
No.
What was the initial argument over?
The argument was.
Okay, and all right. And do you know what the basis of, if you know, the basis of him accusing you? Did you tell him something or do something?
No.
Okay. You made a police report, correct?
Correct.
And did you initially tell the police that he came into the bathroom while you were looking in the mirror and he shook you?
Yes.
Okay. And what happened during that incident?
He started yelling at me and saying, why you make me do this and why you do this to me?
And do you know what he was referencing? Okay, and you weren't cheating on him, correct? All right. And how did that incident end? This specific incident in the bathroom?
Bathroom, I told him that he had to go. Now he couldn't be there.
Okay. And what happened then?
About it, and I started to grab his things, and I told him that either he had to leave or I was gonna tell the people at the front desk to put him out.
Okay.
And then that's when he grabbed me and put his arm around me and pushed me on the bed. And like my face was in the bed, and I kept trying to tell him I couldn't breathe. I kept telling him that I was lying.
So you just testified that he choked you. He never did choke you, correct?
He did.
When did he choke you?
After I started saying I couldn't breathe, like he got off me and he put his arm around my neck.
Okay, so let me get this straight. So you say he bear hugged, is it a fair statement he bear hugged you and forced you on the bed face down?
Yes.
That's what you told the police?
Yes.
You then told them you can't breathe?
Yes.
How long were you face down on the bed? And were you telling him I can't breathe?
Yes.
And then how did you kick him or how did you get up?
Yes.
All right, and then it's your testimony today, then while you're still laying face down, he choked you?
Yes.
And how long did he choke you for? Did you tell that to the police that he choked you?
Yes.
If it's not mentioned in the police report, maybe you didn't tell the police that he choked you? right? And at some point, he let you up?
I gave him into the dresser. And that's when he was off me and I looked off the bed onto the floor.
Okay, and what happened then?
They're trying to take my knee off because I couldn't breathe.
Okay, and what happened after that?
He said, why you making me do this? And then he said, he want me to go to jail.
At some point, did he leave?
Yeah.
And you didn't have to kick him out, correct? He left on his own volition?
No, I had the people in the hotel remove them.
From the room?
Yeah.
Okay, so he leaves at some point, correct? Does he come back that day? So you allowed him back into the room that night?
Like I saw him, but I couldn't be in the hotel. I had lost my room due to the incident.
Okay, well, you also said in the police report, and correct me if I'm wrong, the next day you woke up and he was sleeping next to you in the hotel room. Is that not true?
No, this was a different.
Okay, so is this the day after the incident? I mean, the police report says that you woke up the next morning and he was sleeping next to you. Is that right or wrong? But you're saying it's not at Days Inn? Okay, let me back up. Because of this incident, you went to the hospital, correct? Okay, and I believe, I don't know if you went to Trinity Health, but subsequently after that, you went to U of M. Is that a fair statement?
No.
What hospital did you go to? Okay, let me back up. Weren't you taken to a hospital by an ambulance or?
Yes, I was taken to St. Joe's.
Okay, how long did you stay at St. Joe's? Did you describe to them your injuries?
Yes.
Okay. After that, did you contact him, my client? This was at a different motel? Okay. Subsequent to that, did you then meet him at his hotel room?
No, we met at Red Lobster.
Okay, and subsequent to that, did you then stay with him at his hotel room?
It was my hotel.
Okay, what hotel is this now? We had the Days Inn. What's the new one?
This is a motel.
I'm sorry?
Your motel.
Your motel? So you got a new room then after this incident? And then did you contact him? Did you invite him to your room?
Objection. I'm gonna object on relevance. I don't know where this is relevant to the incident.
This is after the.
Correct.
But again, Judge, it shows her state of mind. I mean, if she was assaulted, as she's claiming by this gentleman, I would argue that she wouldn't be accepting a call from my client if that's what happened and then joining him.
If that were true, we'd never have a domestic violence case, would we? Yeah, I didn't think you'd have a response to that. Objection sustained.
What injuries did you incur? Okay, I know you're not a doctor, but I mean, did you have marks on your neck or anything to? Okay, now you say he smacked you. When you were choked, did you have any bruising on your neck? When you went to the hospital, did you tell the doctors you were choked? Did they find any injuries on you as to in the area of the neck where you would be choked? May I have a moment, Judge?
May. might want the microphone.
Oh, I'm sorry.
Sorry.
This may sound a little repetitive, but my clients, have you seen the police report? Have you ever reviewed it?
Yes.
Is there anywhere that you recall that says that he choked you?
This is on the next.
I just asked her if she saw it anywhere in the police report. I think that's a different question.
I mean, I'll overrule the objection. I'll allow her to answer.
Have you reviewed the police report?
Yeah.
Anywhere in the police report, do you recall seeing a statement made by you that he choked you?
I told him that he had about 2 arms around my neck.
In the police report? You told him he bear hugged you, correct? How did he bear hug you? Where were hands? Around your waist? Okay. Okay,
Mr. Fleming, one more outburst and you're out. Go ahead, Mr. Killow.
If I showed you your statement in the police report, could you pinpoint to me where you claim that you told the police that he choked you? To refresh your memory? May I approach, Judge?
Prosecutor know which pages you're referring to.
Page 6 of 13, 6 and 7. May I approach?
You may.
This page and then the following. Did I get a chance to refresh your memory?
Yes.
Judge, may I approach?
You may.
I'm going to ask you one more time. Do you see any statement made by you in the police report that he choked you?
No.
Thank you. I have no further questions.
Can you read it?
Just briefly around there.
Lucinda, at the time of this assault, were you pregnant?
Yeah.
Okay. And you mentioned that you had injuries. Did someone take photographs of those injuries? Was it the police department? Your Honor, may I approach the witness? People's proposed exhibits 1, 2, and 3.
Judge, I hate to make a technical argument. That should have been presented in the initial prosecutor's proof, Your Honor. And
well, what are their photographs of injuries?
I see.
Correct?
Correct, Your Honor.
Okay, maybe.
Are they injuries around the neck area?
One picture,
No.
which I would ask. I don't see an injury, but I'm sure she can testify.
Your Honor, it would be the pictures that she testified to on cross about the bruising on her face and the scratch as well as her hand.
For purpose of the exam, Judge, I still think the only appropriate picture, if the court's going to allow it, is the next picture. But
well, she's testified to certain things that had occurred to her. You dispute them on cross. They should be able to come back to show their evidence.
That's fine, Judge.
So I'll overrule the objection. Go ahead. Yes.
Thank you. Lucinda, what did I just hand you? Who
Who is in those photos? And are those photos fair and accurate representations of the injuries you received from the assault from Mr. Fleming? And can you describe going through each one on exhibit that's marked 1? What is that a picture of? Okay. And then picture 2, what is that a picture of? And in picture 3? Your Honor, at this point, I would move to admit people's proposed exhibits 1, 2, and 3.
Judge, I'm sorry, I didn't hear her answer on the third picture. What was it she said?
I think she said scratches.
Scratch on her.
Scratches on her face? Okay.
Mr. Microphone. No, you go ahead. It's microphone. I just wanted to make sure that your conversations aren't being overheard.
Waiting for me.
I just move for the admission of the people's exhibits 1.
Exhibits 1, 2, and 3 are admitted.
Thank you, Your Honor. May we publish them to the court?
Yes.
My hand closed.
Hand me those. Thanks. Thank you.
Your Honor, 1 moment.
You may.
Thank you. Nothing further.
Very briefly, Jim.
Go ahead.
Did, at any time during this incident, did you hit my client multiple times in the face? Thank you.
You may step in.
No further witnesses. Your Honor.
None, Judge.
All right.
Well, at this point, I will move for bind over as charged. You heard from Ms. Printup about this incident that occurred on August 4th of this year at the Days Inn on Carpenter Road. She testified to the defendant strangling her not only once with his hands, but also smashing her face into the bed to the point where she couldn't breathe. She expressed that she couldn't breathe to the defendant multiple times and had to kick him to get him off. You also heard testimony that this stems from the defendant accusing her of cheating, and then that's where this argument arose from. On top of the 2 strangulation incidents, you also heard of the defendant slapping her. I believe we met the burden of probable cause and would ask the court to bind over the defendant as charged.
Response.
Judge, just very briefly, Judge, if you look at those pictures, Judge, I would argue, again, neither one of us are doctors, but I would argue she admitted there were scratches on her neck. If somebody's going to choke somebody, there's going to be bruising on the neck, Your Honor. There's been no medical evidence presented that my client choked her. I would argue, Your Honor, that she made statements that he choked her. She could not find that in the police report, although she said she reviewed the police report and she told the police that. Judge, I don't think they've met the probable cause burden as light as it is on count 1. I would argue that at most, Your Honor.
Just out of curiosity, how do you make that? You make that argument regarding the choking, but there was also testimony that her head is pushed down into the bed and that at that point she is not able to breathe, which would constitute, at least on the surface, suffocation.
Well, I would argue that when she said she couldn't breathe, he let her up, Judge. If that's what the court believes, he let her up. She obviously, I mean, I'm not trying to be facetious about that. She didn't die. He let her up when she said she couldn't breathe. But she also, Judge, her testimony's got to be suspect. When she said he then got on top of her and choked her after that, there's no evidence of that, Judge. You look at the pictures, there's no bruising on her neck. And the fact that there's nothing in the police that she ever told the police that he choked her. So I would argue again, Judge, that at most, Your Honor, the court should only bind over on count 2. Thank you.
Anything else from the people?
Your Honor, I would just put on the record that in many instances of strangulation, injury is not normally present or able to be photographed. So I think that the fact that there's no injury not only doesn't negate the testimony, but it also isn't an element of the crime.
Right. being a probable cause hearing, the court would find that the people have indeed sustained their burdens as to both counts 1 and 2. I think with the record, you know what, Mr. Fleming? Judge, you got one more time. Am I understood?
Understood.
I am not man. Take him out. Do not ever refer to me that way. Gilwald, I'm gonna give you a minute. I know you're supposed to be downtown, but I'm gonna give you a moment to go around there and check your client before I bring him back out. Because otherwise we're gonna have a problem. So that the record is clear before I call the next case. On the Fleming matter, because of behavior that was going on in the jail cell, behavior in the courtroom, the court, upon taking the after having him removed and upon taking the break, made the decision. Mr. Fleming he was taken back down. He will appear via Zoom since there's no more testimony. It's just my decision. So once they can maybe come down or do whatever, he will appear via Zoom. Mr. Kilowald had to go downtown. He will appear via Zoom. Ms. Zenda, I will leave it to you as to what you'll be here. Bless your heart. All right. Okay, just so that the record is clear with reference to that. Court does call the case of the people of the state of Michigan versus Mark White.
Laura Willenbrand, Assistant Prosecuting Attorney on behalf of the people.
David Knopf on behalf of the defendant, Your Honor. Your Honor, we were in the middle of, I was making the argument that after the claimant had testified, got page 14 of the preliminary exam transcript, under oath today, you're sure it happened at 8272 Blue Jay, correct? Yes. He had just bought the house. Yes. There is zero doubt in your mind about that. There is zero doubt. You're as confident that this occurred at 8272 Blue Jay as you are that it occurred, right? Yes. And you know it was 2017 because you were coming back from the Lewiston Wayne State game. Correct. In Illinois? Correct. And I showed you a warranty deed that the house was purchased in 2018. And you said, I want to hear from a witness who can say he wasn't living there as a renter.
Well, I don't think I said that.
Okay.
Right.
You said, you gave me the opportunity, whatever exactly you said. I don't want to put words in your mouth. Anyway, I've got a witness. And I'd like to call Darian Owens, please.
All right. Sir, please come forward to be sworn.
Sorry, Your Honor, I'm going to ask that witnesses be sequestered because I might recall the victim in this case.
All right. Witnesses are sequestered.
Raise your right hand. I'm swearing for testimony about the guilty, the truth, the whole truth, and nothing but the truth. So, see, stay so your first last name to the record.
Darian,
All right. You may inquire.
Mr. Owens, what do you do for a living?
PE teacher right now.
And where do you teach? How old are you? Do you have any kind of criminal record? Okay. What is your relationship, if any, to Mark White? Okay. In 2017, were you in school?
2017, graduated high school. In summer, I went to college.
Okay. And where did you attend college?
Wayne State University.
And so in the fall of 2017, were you playing basketball at Wayne State?
2017, yep.
Were you at a game in Illinois?
Yep.
And at that time, where did your father live?
Trillium and Hyde.
Do you have any doubt in your mind that he lived at Trillium rather than at Blue Jay? Okay. Did you ever spend the night at Trillium?
Lived there.
You lived there with your father and your stepmother? Okay. And so you were at Wayne State in college but you considered Trillium home in 2017?
Yeah.
It was your home?
I wasn't in my home dorm or apartment. It's at home.
Okay. Do you remember Mariah Hamill? Do you remember her attending the basketball game in Illinois? And do you have any knowledge about, like, did you spend the night yourself at Trillium that night after the game? Okay. Did you celebrate Thanksgiving at with your father and your stepmother at the Blue Jay House ever? Okay. In 2018, did you celebrate Thanksgiving?
Yes.
Was Mariah Hamill present for Thanksgiving in 2018? And that was in the Blue Jay House. But at Thanksgiving in 2017, it was Trillium, right? Okay. Nothing further. Thank you, sir.
Cross-examination.
Thank you. Good afternoon. My name is Laura. I'm going to ask you a couple of questions. So when you graduated in 2017, you were living with your dad at the Trillium address. Did you spend every night there?
Was that a yes?
Yes.
Go ahead.
Did you spend every night there? No. Did you also live with an aunt? Where did you spend the night when you were not spending it at your father's?
Well, we put it wherever I wanted to.
Wherever you wanted to? Okay. And did you move out in the, say, summer of 2017? Is that correct?
No, not completely. I went to college.
Okay. Okay. So you remember also in 2017, you testified, you remember Mariah Hamill coming to your basketball game in Illinois, right? Okay. Did she come to other basketball games of yours? For sure. Okay. In 2018, did she come to basketball games of yours? She came to a basketball game. Okay. And did Mariah spend ever the night at the Blue Jay house? You don't recall because you were not living at the Blue Jay house?
I don't recall, but I wasn't there.
Okay. And you said that as of Thanksgiving 2018, your father was living in the Blue Jay house. Okay. Can you describe the Blue Jay house?
Textile subdivision, his house, front yard, long driveway. Now we got a basketball hoop.
Well, big, 2 stories? Okay. When you walk in the front door, what do you see?
Walk in the front door. Staircase. Maybe not a room. I don't know specific names of the room, but big table in this room, I'm gonna call it a room where like couches are.
Okay. And where are the bedrooms in the house?
Bedroom, you walk in, walk upstairs, one room to the right. And 2 on the left, no, 2 rooms on the right, 2 on the left, in the bathroom.
Okay, so all the bedrooms are upstairs though?
Yep.
Okay. What is the backyard like?
Small backyard, we got a little mini patio.
Okay. Does it look out to, like, are there other houses behind it that you can see from the backyard? Okay. How do you feel about being here today? Okay, no further questions, Your Honor. Thank you.
Any redirect?
In 2017, you played basketball in Illinois. In 2018, when Wayne State played Illinois, where was the game held?
2018, Louis University, played at Wayne State.
Thank you. Nothing further.
You may step down. Any other witnesses for the,
No, Your Honor.
any rebuttal witnesses for the people?
Yes, Your Honor, I am going to recall Mariah Hamill.
All right. Please come forward to be sworn.
Check out this beautiful new roof we just finished installing.
Take a seat, raise your right hand. You solemnly swear to confirm the testimony you're about to give the truth, the whole truth, and nothing but the truth. See, thanks for your first life and the record, please.
Mariah Hamill, MORIYAHAMELL.
May inquire.
Good afternoon, Ms. Hamill. You previously testified in this case. Do you remember that?
Yes.
Okay. And you previously testified that the assault that you described occurred at a house on Blue Jay.
Correct.
Okay. And what do you remember about that house on Blue Jay? How would you describe it?
Well, outside of the house, it was a garage, like the driveway will turn into a garage. Couple feet from the garage door, there was the front door. I just remember, well, what I really liked about the house, that really stuck with me was that like once you enter the home, it's a stairwell and it's literally like space right there. So and it was like a big window over the doorway. I don't like that. I remember, it was, so if you go upstairs, as soon as you go upstairs, it's bathroom, it's a full bathroom, and then on the side of that, it was the master bedroom, and then right next to that master bedroom, it was a guest bedroom. And that's where I was during the time of being at the house.
Okay. And were there other bedrooms upstairs?
Yes, there was another bedroom with his two younger sons in that room.
Okay. And what do you remember about the backyard?
Not too much. I didn't never. Never.
Okay. And you previously testified that you were pretty certain about the year that this occurred and that it was in 2017. Okay. Could it have been 2018?
Objection leading.
Overruled, I have the answer. Go ahead.
Why?
Well, with this being done to me so long ago, I kind of was trying to fill in the pieces. And I was determined that it happened in 2017. I knew for sure that it happened between 2017 and 2018. I just wasn't, just couldn't clarify which year did it happen until I got the evidence that I needed that it had happened in 2020 instead of 2017.
In 20, what year?
Sorry, 2018 instead of 2017.
Okay. And did you ever go to another house that the defendant owned? You had only ever been to the Blue Jay house. And did you only spend the night there one time?
No.
You had spent the night there in additional times?
Yes.
Okay. And you testified that you had gone to a basketball game.
Correct.
Okay. And you had testified previously that you believed it was the Illinois game in Illinois.
Yes.
Okay. Are you certain of that?
No.
Okay. What game do you think it was?
No, I'm sorry. I'm pretty sure that it was Lewis University versus Wayne State. I just wasn't accurate about us possibly driving down to Illinois instead of us going down to Wayne State University.
Okay. Did you go to a lot of Wayne State games? Okay. Did you go to a lot of Wayne State games with the defendant? Okay. May I just have 1 minute, Your Honor?
You may.
No further questions, Your Honor. Thank you.
Where is Wayne State University? Right. And in 2018, where were you living? What city or town? Yes. In 2018, where were you living? Okay. And where is Blue Jay? What town is Blue Jay in? Okay. So today, your story is that after a Wayne State basketball game at Wayne State, you went past E-Course to Ypsilanti to spend the night at the defendant's house. That's your story? Why didn't you remember that before?
Because it happened when I was a minor. And this is not something that you will really want to remember. So I'm kind of, still trying to figure out everything that did happen so I can get justice for myself. And
Okay, you were positive when you spoke to the police on multiple occasions that it happened in 2017 after a basketball game coming back from Illinois, right? But when you were videotaped being interviewed by the police on multiple occasions, that's how you testified, right? Statement. And the last time we were in this court, you were clear as a bell about your testimony, right?
I'm sorry, what's your name? Sorry.
I'm Mr. Nacht.
Mr. Knox. Have you ever been sexually assaulted?
Ma'am, regrettably, you don't get to ask questions. You just need to answer yes.
Okay.
Thank you.
You were clear as a bell last time you were here that it was after the game in Illinois, you were driving back and you got a ride back with the White family and you spent the night at the White House, right?
I was clear about it being a basketball game that I've been to and us going back to the house and everything happened how I was clear about that.
Is it possible it was on Trillium instead of on Blue Jay?
No, I've never been to the house.
I see. Is it possible that this happened with someone else in some other house?
When I build relationships with people, I love hard, I do everything. So when I looked at Mark White as a father figure, that was something that I would, he affected me, like he affected me in a way that no one else could.
You did do Thanksgiving at the Blue Jay house in 2018, correct? Okay. So you last time said you never went back to the Blue Jay house after you were assaulted, right?
So everything aligned with each other.
I understand. You're changing your story to clarify everything. What specific things triggered your memory that it was a game at Wayne State and that it was in 2018. What triggered your memory to change your story from the last time you were here to today?
Research.
Please share.
Finding out, just me trying to get to the basis of this situation when it happened. I kind of just went with what am I for?
The second the tweet went out, I was vehemently attacked. I disagreed with them on this one topic, and all of a sudden, I just immediately went out of my dream into a nightmare.
So not your memory, but research.
It's my memory too, also with the research, yes.
What precisely did you research that influenced your memory?
Well, around the time that this incident happened, he was about to get fired from River Ridge High School, which was the high school that I was attending at the time. And it was because of a rumor and another incident that happened. So
And why would you have gone past E-course to spend the night in Ypsilanti if you were attending a basketball game in Detroit and you lived in E-course?
because when I was living in Egress, I was always home alone. My dad didn't live in Michigan. I had a aunt and my grandma who lived at the house at the time too. And my grandma, she was a dialysis patient, so she could really care for herself. My auntie, she was in and out of the house, so I didn't want to be alone. And I, like, again, viewed Mark White and his family as my second family. So I was comfortable enough to go back to his house with him and his family, and that's how comfortable they made me at one point.
Ma'am, I hear your testimony that trauma has affected your memory. I hear you. And I guess I'm asking you if you could testify with such certainty that it happened in 2017 after the game in the state of Illinois. And now today you're testifying with certainty something very different. Is it possible that the way the trauma and the research all mixed together with your memory that you might testify differently in front of the jury or another time? Are you sure? Even if it could be proven to you in a way that would satisfy you from research that Mark White didn't live and was not present in the Blue Jay home in 2018?
But he really was. So there's no me not getting not identifying him as who he is. Like I said, he made a huge impact in my life. So I know for certain when he made me feel loved and when he hurt me.
Okay, thank you.
Ma'am, the game that you thought it was in 2017, who was that game between?
The two teams was Lewis University and Wayne State University.
Lewiston University. Do you recall what month that took place?
November.
In November, in 2017?
Yes.
All right. So now, and you said Lewiston?
Lewis University.
Okay. And they are in Illinois?
Yes.
Okay. All right. And in 2018, now, as you're reflecting on it, in 2018, when you were headed back from Wayne State, do you recall the two teams?
The two teams. Okay, so we've been to a lot of college games.
No, I got you.
Hang
Hang on a second. Okay. I'm asking for a specific reason. That game the night that we're talking about, Okay. Do you recall who Wayne State was playing?
They were playing Lewis University.
Right here.
Yes. They played twice within the same month, just different years.
Hang on a second. Twice within the same month. They played 2 years in a row, same month.
Yes.
Is that what you mean to say?
Yes.
Gotcha. Okay. So in November 2018, it was Lewiston, right? But here, or in Michigan. Okay. Any questions based upon the court's questions?
Nothing for the people.
Mr. Knott.
Just so I understand your story, you're confident it's Lewis University in 2018 at Wayne State University. Was Mr. White at that game?
Sorry, which Mr. White? It's 2 months in.
The defendant.
Yes.
He was at that game.
Yes.
And you're as confident of that fact as you are that he assaulted you.
Yes.
And did you have a conversation with Tanisha White or Mark White about spending the night at the White House in Ypsilanti? Coming from Wayne State?
I don't recall having a conversation, but I know once, I know that if I did stay the night at the house, it was a conversation about being asked if I wanted to stay here or me just telling them that I didn't want to stay here. So yes, things were mutual when it came time to me staying at the house.
Nothing further.
The time where you came back from Detroit, which says now 2008. When, let me strike that. When these events happened to you, how close in your recollection was it to Thanksgiving? You don't know? Okay. Okay. Any questions based on the court?
No.
All right, thank you. You may sit down. Any additional witnesses for the people?
No, no further witnesses, Your Honor.
Counsel, has either side looked at the Wayne State schedule?
Yes.
I'm sure everybody has.
Yes, Your Honor.
All right. Because in one year it occurs on November 17th and the other on November 25th. I just know that off the top. No, I'm kidding. Right? Just so that we're all talking on the same page. Additional argument.
Your Honor, I am first going to move to amend the complaint to amend the date range. It's currently, I believe, 10/1/2017 to 10/31/2017. I'm going to amend 10/1/2017 to 12/1/2018.
12/1/20. Gotcha. Okay, because it was previously amended to 10/1/17 through 10, it's like 11/18. You're just extending that last date to,
Yeah, and I actually, I believe probably looking at the same, is it a handwritten, correct?
yes, with, I think it was done by Magistrate Ortella. Those are his initials.
I think it is a 7 with a dash through the middle, but regardless.
Gotcha. Oh, on the last one, I got you. Instead of a 9.
Yeah.
I see. I see what you're saying. So you want it amended October 1, the last date to December 1,
2018.
2018.
Yes, that's correct.
Any objection or response to that?
Well, I mean, we would object to allow the date to be amended. It's prejudicial, especially given the testimony that the witness previously gave under oath. And you remember, I was boring you by repeatedly asking the question to be so clear because I knew it couldn't be true.
It wasn't that part of you that was boring me.
I understand, Your Honor. I have that effect on other judges too. So we would object that it's prejudicial.
Well, I don't know that it's prejudicial. I'm going to allow the amendment. I mean, oftentimes you start with a date, the witness testifies, and then the information has to be amended in some fashion or the date has to be changed. So, all right.
Okay. Thank you, Judge. I am going to move for bind over on counts 1 and 2. Your Honor is well aware that we began the testimony some months ago from Ms. Hamill, who was very pregnant at the time. She testified that she met and developed a trusting kind of father-like relationship with the defendant, Mark White. He was a basketball coach and she did workouts with him because she wanted to play D1 basketball. She, at that time, testified that she went to a basketball game of Lewis University versus Wayne State with the defendant and his family, and then came back to the Blue Jay house, which she described today as you walk in, staircase upstairs, bedrooms are upstairs, the same way that the defendant's son, who testified today, described entering into that house. She testified that she stayed the night and she woke up with the defendant having his mouth on her breast that was exposed. And then he asked if he could touch her and taste her, to which she said no, and that she was feeling uncomfortable. She did, frankly, have the year wrong. At the time, she was 16 or 17, and this was, at this point, 7 years ago. And she did not waver, though, on what happened to her, that she trusted the defendant and he sexually assaulted her. She remembered that it was in the Blue Jay house because she'd only ever been in that house. She remembered details of the house, but she was wrong on the year, and she testified to that. I also don't need to remind the court that the people do not have to prove time as an element of a criminal sexual conduct, and I don't think that her mixing up a year that she was sexually assaulted by the defendant when she was in high school is honestly detrimental to her credibility at all. I'm asking for bind over on count 1 and 2 based on her testimony that the defendant sexually assaulted her.
People are hitting a new low in claiming probable cause in this case. It's absolutely incredible that when confronted with evidence that it couldn't have happened in the year because the defendant did not reside in the house in that year, magically, the plaintiff or the claimant, citing research, which she cannot identify a single thing she researched, except referencing that she vaguely remembers there were rumors about my client, That's all she has to say, oh, it was actually a different year. But she can't explain the very detailed account of returning from Illinois, heading east, stopping at the house in Ypsilanti, which makes perfect sense. It makes zero sense that she would come from a basketball game at Wayne State, pass her home at Ecorse, and go all the way to Ypsilanti. It's a completely different account, a completely different narrative. And so if we allow claimants at preliminary exam to completely alter their narrative, it's not just about getting the date wrong. It's about getting the narrative wrong about what happened on the evening, the day of the alleged assault, and claim that that's probable cause. It's simply not probable. It's just not. I mean, what's probable? That something happened to her at some point by someone, somewhere? It's a terrifying thing to go to trial on a felony. And we protect people in this state with a preliminary examination that allows cross-examination of claimants. Claimants are routinely found credible because frankly, they routinely are credible. But the discrepancy between testimony that was given, confrontation with the housing purchase date where she stuck to her story last time and said, no, it's 2017. Then today, after we put a witness on, she's now at 2018. And it's a totally different account as to where she's coming from. It's simply insufficient to be probable. Is it possible? Of course it's possible. Is it probable that a felony was committed and my client committed it? No.
May I just briefly respond, Your Honor?
Right.
I frankly believe that the witness that the defense presented corroborated Mariah's testimony. He said that she came to all the basketball games and that he remembers her like spending the night at that house, that they were like together, they went to all the basketball games and that she stayed overnight. So I think that if anything, the witness they presented corroborated that part of her testimony.
Anything else, Mr. No?
No.
Excuse me one moment here. I just want to get this. The testimony of Ms. Hamill was certainly, I guess, at issue. One of the reasons why, or a number of different reasons, why time doesn't have to be shown in that fashion is because memories do lapse. Memories don't necessarily change, but there are certain things that individuals who may be victims of assault may not remember or may not be able to pinpoint. I agree with the people in this respect, and that is that the defense's argument that it was illogical to come from Detroit and drive past Inkster and go to this house, as that wouldn't make sense as she would have stopped at Inkster. While that certainly might be an argument, the witness today, Mr. Owens, contradicts that argument by indicating specifically that she was at the game, she was at all the games, she was at the house, she was there to the extent that he was at least there and would recognize it or be able to testify to that, because sometimes he just stayed wherever he wanted to. But when one looks at this case, she is definite about one thing that's important for the court's perspective. She is definite as to where it occurred. What the defense wants me to do is say she's not telling the truth, and I can't say that. Part of the reason I can't say that is because you were asking her questions about when it happened, where it was. At the last hearing, she was unflinching. She knew where it happened. Question about when it happened may be at issue. Oddly, in this case, and maybe this is something that has to be determined by a fact finder, Wayne State plays Lewis in November, those 2 years. One time on the 17th and one time on the 25th. I tried to kind of pinpoint it, but she didn't, because she didn't know. I mean, I'm not saying she was hiding anything from me. I was trying to ask, was it near Thanksgiving, or could she make it relative to Thanksgiving? And she couldn't do that. Frankly, had she wanted to lie to the court because she was making something up, she would have very easily been able to say it was closer to Thanksgiving or not as close, depending on whether it was the 17th or whether it was the 25th. She didn't do that. It is likely she had her year wrong. She knows the game. She knows the team. She knows the game. She understands that. She understands that there was travel. Mr. Owens indicates she would travel with them. She was young at the time, and she's here today to tell this court under oath that when she's looking back at it, that it's 2018. May not like it, but I don't think her story, the crux of her story about what happened to her, did not change one iota. And those things surrounding it didn't change. It is not unusual for somebody who's a victim of sexual assault to be able to say certain things dawn on them. I don't think I would have remembered if I went to a series of basketball games. I don't think that I would have remembered any given team at any given point. And I say it as a sports fan, I just wouldn't have remembered. But the one thing she remembers about that night, Wayne State was playing Lewis. She may have had the wrong spot about where they were playing it. But she didn't narrow it down specifically as to a date. She's using reference points around her to get us there. That reference point at the university of who Wayne State was playing, the reference point of the house, her description of the house, which matches Mr. Owens' testimony that says she would come from the game, she would go to all these games and come there. Lead this court to the conclusion that the defendant, that the people have sustained their burden of showing probable cause, that the defendant ought be and will be bound over to stand trial on both counts, and that the issue regarding, and I don't know that it's necessarily an issue of credibility as it is an issue of recollection, that needs to go to a fact finder to decide. And so it will go there. Defendant is bound over to stand trial on both counts.
Move the bond continues.
You have to do the arraignment, Mr. Knox. Bound over on 1 and 2. You acknowledge receipt of the information or waive its presentation as the dates have changed. Go ahead, sir. You need to come to your attorney. No, go ahead. You look like you needed to say something to your counsel. So before we, no, you're good. It's just if you needed to say something, Mr. Knott, go ahead, sir. Okay. So did you want presentation of the information?
No, no.
All right, so you're waiving.
Waive reading and stand mute.
Defendant having waived former reading, standing mute as to both counts, court will enter a not guilty plea. Pre-trial in this matter will be set
November 5th at 1:30 with Judge Collins.
November 5th, 2025, 1:30 before Judge Conlon. Bond in this case with its conditions will continue. Thank you. Court does call the cases of the people of the state of Michigan versus James Michael Daniels.
Sherilyn Foster Tucker on behalf of James Daniel.
And Your Honor, Alex Warren Green on behalf of Mr. Daniel in the matter ending 1320.
And your name, sir? James Daniel. All right. He's waiving preliminary examination in both cases.
That is correct.
Correct, Your Honor.
Sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
I understand.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one in both cases.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute in 1320.
Also acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute in both cases, court will enter a not guilty plea. Pre-trial in these matters will be set for
October 30th at 1:30 with Judge Slay.
October 30th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond in all of these matters will continue.
One.
Oh.
This was a waiver. The people were agreeing in exchange for the waiver not to add additional counts of felon possession of a weapon or felon possession of a firearm.
Yes, that is correct, Your Honor, in my
Correct.
case.
In your case?
Yes.
Okay, that's kind of important. All right, thank you. All right, thank you. Bond will continue with its conditions.
Okay, thank you, Your Honor.
Thank you, Mr. Daniel.
Thank you, Your Honor.
Court does call the case of the people of the state of Michigan versus Jerome Burns.
Good afternoon, Your Honor. Marie Tenhouse, Assistant Prosecuting Attorney on behalf of the
And Assistant Public Defender Chinaza Carey, I can really, Your Honor, on behalf of Mr. Jerome Burns.
All right.
For the record.
Jerome Burns.
Okay. All right. I think we have one more witness.
So, Your Honor, at our last preliminary exam, the people did take testimony from officer in charge.
Yeah.
And Michael Matthews. Oh, I see Michael Matthews. Your Honor, we don't have any questions for Mr. Matthews, so we would go ahead.
You know, that's okay. It's been that kind of day. Everybody tells me they have two witnesses, they have one.
Quick, not quick.
What?
I said, they'll say it'll be quick, it's not quick.
Exactly, exactly. Had I known, I would have called you before Mr. Knott. All right. Okay. Any additional witnesses?
Not from the people, Your Honor.
And none from defense.
All right, motion.
Your Honor, the court has heard plenty of testimony in this case at this point. If there's motion for finding the count stated as a complaint.
Response.
Your Honor. Mr. Burns is charged with criminal sexual conduct in the third degree by use of force or coercion. I want to bring the court's attention to the statute that describes or determines what force or coercion is. And specifically, Your Honor, I'm pulling this from the CSE first statute, subsection F, describes force or coercion. It says it includes, but it's not limited to any of the following circumstances. And I, for the purpose of making the record, Your Honor, I know that the—
Go ahead.
When the actor overcomes the victim through the actual application of physical force or physical violence. Number two is when the actor coerces the victim to submit by threatening to use force or violence on the victim, and the victim believes that the actor has the present ability to execute these threats. That is the definition that we're looking at when we're talking about coercion, Your Honor. And here, the testimony that has been provided today, I do not believe, and I'm hoping that the court does not believe, reaches the low burden of probable cause to determine whether or not my client used force or coercion to gain this sexual act that he had with Ms. Burns. She was not able to testify to anything articulable in regards to repercussions if she did not. I know that consent is an issue for the trier of fact. However, Your Honor, I don't even want to go into her consent too much, because the fact of the matter is she stated that she allowed or said or agreed that they would have sex one last time, because the testimony was kind of inconsistent, in my opinion. Specifically, what she had told the officers, Your Honor, was that she did it out of fear of harm to her or her child. When I asked her on the stand whether or not he had ever done anything to the child, she testified no, that he has never harmed their child. Also, Your Honor, when I asked her as to why she had allowed or accepted the advance and agreed to have sex, she brought up something about him stating that he had overdosed on pills or that he had taken a handful of pills. She tried to liken that to a prior situation where she claimed that he had tried to commit suicide in front of her, Your Honor. But at that point, we were able to bring out the fact that ultimately she did not believe that he had taken any of those pills, because she didn't ask for help from any of the medical professionals that were in and out of that hospital at all. Also, Your Honor, she said that her testimony came out that she felt that he just kept asking her for sex, and she ended up saying yes so that he could stop asking her. None of that at all meets the requirement for force or coercion, Your Honor. There is no reasonable fear that anything would happen to her or her son if she did not consent or if she did not agree to the acts with my client, Judge. Secondly, I want to bring in, I know the court has a determination, although most of these cases are bound over, that at this stage, the court can make a determination on the credibility of a witness, Your Honor. And I have issues, and I hope the court sees issues with Ms. Burns's testimony and her credibility overall. At one point, she's saying that she wasn't allowed to have a cell phone. I mean, she wasn't allowed to have a bank account. Then she remembers that there was a Chime bank account. She wasn't allowed to have a cell phone, or she had to keep her cell phone, but she had the secret cell phone. And I understand the people's theory. I understand some of the statements that were made by Ms. Burns today as well, indicating the reasons behind that, Your Honor. But honestly, there's a lot of untruthfulness. It was guised or covered under the guise of, I don't know, I'm not sure, I don't know. But realistically, Judge, we believe that that is just untruthful statements that were provided today by Ms. Burns. The delay in her report, she indicates that they came to the hospital on a Monday. This sexual act happened on a Wednesday, but she didn't report it until Saturday. Throughout that week, she did testify, Judge, that there was an instance or two. My client was in and out of the hospital. She also testified to her leaving the hospital after the sexual act had occurred, but a day before the actual, when she finally told someone about this act. But one thing that did happen on that Saturday that she told, Judge, was the testimony that we were able to bring out today, where she agreed that my client had access to her phone because or her tablet, either or, that she was going to post something on Facebook. Now, I understand that she did not admit, or she did not testify to knowing that he had gone through his phone, her phone, but I think that those statements alone on that day go hand in hand with the statements that were provided by Officer Eric Morton, where he indicated that my client told him that the reason she's doing this was because she cheated on him and he found out about it. what the timeline is just very concerning for me, Judge, that this happened on a Wednesday. And I'm not victim blaming. I know that sometimes the people have objections to us making these type of statements, but this happened on a Wednesday. She left the hospital with another individual on Thursday, was gone for however long, didn't report it to that person, which is a trusted person who she claims she walked by orderly, she walked by security, she walked by nurses. So any fear that she may have had, Your Honor, is very unrealistic in this matter. She left, she went to an event for her father's going home ceremony, and she came back. She didn't report anything that night. It wasn't until Saturday, after the interaction with my client and her phone, that now all of a sudden, there is some type of report that needs to be made to someone. Judge, all in all, I know that the standard at preliminary examination is very low. However, there has to be some consideration on whether or not a trier of fact would even be able to determine that this type of offense actually occurred. And with the information that we've been provided with all of the testimony that we've taken out, we are urging the court to see that if and when this goes up to a jury, a trier of fact is not going to believe that anything happened because the elements of this offense have not been met, even at the level of probable cause, Your Honor. So we are asking that the court not bind this matter over. We're asking that the court dismiss these charges against my client. Thank you.
Thank you, Your Honor. Your Honor, it's interesting that defense talks about credibility. This court saw this witness testified. This court noted her demeanor, her clear testimony about what happened under hours and hours of questioning by both sides, her willingness and the length she went to continuously come back adjournment after adjournment after adjournment and testify in front of this court, in front of her abuser, being questioned by professional attorneys for hours. That all speaks to credibility. So I don't need to bolster her credibility at this point. The judge can Your Honor, can make that determination for yourself. This is a case where we never claimed there was any physical coercion. He didn't hold her down. He didn't restrain her and sexually assault her. What he did is take someone who he had very perfectly groomed. This was probably one of the most stereotypical victims of domestic violence, intimate partner violence I've seen, and that's saying a lot. He took someone, he abused her multiple times. She testified she had been abused physically and sexually before this incident by this defendant. There are pending cases. There's a CPS investigation because the abuse took place in front of their child. So while he may not have directly harmed the child, we don't know. We don't have any evidence of that right now. We certainly had testimony that he physically and sexually abused that child's mother in front of this child, who, by the way, is a sick child with special needs.
As an online student, Carrie wanted me to be involved in the various different programs that they offer graduates.
On top of this fear that she was going to be physically and sexually assaulted in front of her child, we also have the fear she had about this defendant taking that child away from her and not allowing her to ever see him again. Not only did we hear testimony as to that, it was direct testimony from the victim when she was asked about why she gave in. And that's what it is, truly, was giving in. She didn't consent, she agreed. Because in that moment, she chose to sacrifice herself and her body to keep herself and her son safe, which is a choice I'm sure many parents would do, as sad as that is. And this defendant put his child's mother, his wife, in that position. He put his child in a position where we had to have the child come here now twice. I mean, this is so concerning. The dynamics are so perfectly fit, that controlling behavior, that, you know, we want to talk about credibility. I could go on and on. Regardless, so she has a threat of physical and sexual violence by this defendant. She has the threat of not seeing her son again. That threat is confirmed. We heard testimony from the jail calls where he is talking about, he's telling his family that he's going to take his son away and the victim will never see him again. In his own words, for God's sakes. What we then also have is when this case is pending, when he has been warned about what he is allowed to do and not allowed to do, when he's been ordered by the court to pick up a vehicle to the child's mother. Again, this is a sick child who needs special medical care. This is a victim who, after all the sexual and physical abuse he's put her through, not to mention the emotional and verbal abuse and complete control of her in her life, has nothing. She's at a domestic violence shelter. She is starting from scratch with a sick child. And this man, if he wants to call himself that, thinks it's appropriate to have a bank go and repossess the truck, the only means of transportation that would be reliable, where she wouldn't have to rely on other people's graces, for them to go repossess the vehicle at the domestic violence shelter. And he's laughing, thinking it's funny that they should do it while she's unloading her things. I think that says a lot about the kind of person he is. And normally I stand up here and we don't go into the kind of person the defendant is. We say people do bad things, they're not bad people. I would say his behavior has demonstrated that we are far past that. Your Honor, we have testimony about the level of control, the fear this victim felt, and why she made the choices she made. I'd argue, Your Honor, at this point, this defendant has been given the benefit of all his rights, the benefit of doubt, the benefit of coming back here time and time again. We have all been very patient, as we should be, with this case. But the testimony is clear, Your Honor. We heard from the social worker, and I would say the social worker just added to the level of evidence we see that this was a case of coercion. I mean, she described the victim's demeanor, how she was fearful, how timid she appeared, how afraid she was. We heard from Officer Morton, who stated that defendant in his own words talked to them about how easily it is to coerce this victim. I mean, out of his own mouth, he talked about how easy it is to coerce his victim. And again, that says a lot about the kind of person he is and how well planned out this was. Your Honor, with all of that, with the testimony the court has heard, we would ask for you to bind over. Thank you.
In this case, in the court, and I want to say that I appreciate counsel, not only because I think both of you acted in an exceedingly professional manner, but also making sure that evidence, while not coming into this, was at least examined to the extent it could have been to the defendant's benefit. This case, I will say, is disturbing in a number of different regards. I would have to agree with the people that this is one of the most disturbing types of relationship in regard to control. I watched as Ms. Burns testified, and as she's testifying, frankly, and I'll just say it right there, I found her exceedingly credible in terms of what she was saying. She was describing a life that, to say it this way, I don't know was much of a life if one is talking about free will and your ability to do what you wish. One of the things that sat with the court regarding the control that this defendant exerted over her was her inability to take a walk and just get some fresh air without being told that she had to go back home. The idea that she had shoes that she liked, but that she had to hide them because she could only, as she testified, wear the shoes that he got. Certainly, I listened to the defense regarding this other phone that she has, but remember, she has that phone tucked away in the back of a desk and is of extremely limited financial resources to activate that phone and to have that, basically to have a plan, or at least to have that. This was an individual, she testified, who is trying step by step without being found out to try to plan her escape from what is this psychological prison she's in. When we deal with the issue of coercion, she doesn't, what is clear from her testimony, and certainly what the court got, she's not entirely sure what he will do. She fears the worst because of the way that he acts and she's treated. So when asked the question about would he do that in terms of committing suicide, I don't know if her answer was really no, he wouldn't, whether that was an actual fact of her thought process or whether that was just her hope. Did he believe that she wouldn't take the child? She said that she wasn't sure about that either, and that she didn't know or didn't think so, but was she fearful of it and legitimately fearful of it? Yeah, she was. And like the people have brought up, the defendant's own statements show that at least that was something that may have been within the realm of possibility. The defense talks about the delay. And I will say that as I watch Ms. Burns testify, she is a very fragile individual. She hasn't gotten to experience the world and has been kept from it. And in a world which she really, I don't think, wants to be in entirely, is sort of created around her. And I bring that point up because there was then the issue that the defense brings up of her delay in reporting. Certainly, it's not from a time perspective, it's not a huge amount of time. The defense points to the fact that she is doing these other things. She's with somebody, she's not saying it. I'm not sure when the defense says it's a trusted person, I'm not sure she knows who entirely to trust. I also, when you think about it, and if you listen to what her life is, she, in that interim period, she's dealing with a sick child and a death. There's a lot going on for her. And then you have this other issue, and it's another sort of thing that she's got to figure out what to do with. And is extremely fearful of making the wrong call. Say, was there any threat to her? And given her entire explanation of her married life with the defendant in this case, yeah, there's coercion. There's coercion, and it, quite frankly, when you hear it all, it's not a subtle coercion. He knows exactly what he's doing to make her do. He knows how she will respond, because she won't respond to stand up for herself as most people would view it. she responds from a point of just preservation. That is her whole life. And when given the opportunity to explain, she told this court that she gave in. He kept asking for sex. She gave in. Reality is, he knew she would. She said, in her own words, he was worried he was going to take the child or to kill himself. She says that. And maybe the reasonableness of that thought can be argued, but if that reasonableness of her thought based upon her existence, I think it's reasonable that that's what she fears. She clearly, and this is the sort of the interesting thing, because I don't think she had many avenues to express it previously. She said it was against her will. That it felt like it was against her will. And then after the defendant's act, he basically has to ask her, are you mad at me that I made you do that? Or the like. Of cases that I've been involved in over the times that I've been on the bench and as an attorney, this is one of the most compelling in terms of psychological that I've seen, especially when you see Miss Burns and you see just the effects of her being victimized day after day after day. Everything controlled. Everything. She has to march in a certain way. And, you know, she's hiding shoes, for God's sakes, because she fears what the defendant will do if he has this, if she sees that he has those shoes. Incredible. For those reasons, and because I find the testimony of Ms. Burns to be very credible, the court would find that the people have indeed sustained their burden and would bind the defendant over to stand trial as charged. Second reference.
Your Honor, we acknowledge receipt of the information, standing mute, asking the court to continue my client's no guilty.
And then having waived formal waiting, standing mute, court will enter a not guilty plea on his behalf. Pre-trial in this matter will be set
November 4th at 1:30 with Judge Combs.
November 4th, 2025, 1:30 before Judge Combs.
Thank you, Your Honor. May I sign the information?
Yes, bond is continued.
What's up? Judge, my apologies. Judge, can you hear me?
Yes, we can hear you, Bob. It's
I
okay.
I really do apologize. I think, never mind. I think I fell asleep, but no, just kidding. Is my client also on Zoom?
He's been on Zoom. Yes, now he is. I think he is. All right. Court does recall the case of the people of the state of Michigan versus Brandon Fleming.
Alexander on behalf of the people.
Good afternoon, Your Honor. Robert J. Kill on behalf of Mr. Fleming. Brandon, would you state your name for the record, please?
Hello?
Yeah, state your name.
Brandon Fleming.
All right. We were at the point in the preliminary examination and I was giving my decision on bind over. In this case, the court would find that the people have indeed sustained their burden. The case, while certainly the defense may make some arguments regarding the police photos of particular injuries. The court, having heard the testimony of Ms. Printup, the court, well, that testimony, any dispute regarding what she is saying, what's in the police report, that the court would find constitute factual circumstances, which which rightfully should go before a fact finder and should not be the subject matter of these proceedings. I would also indicate, because I believe that I was at the point of the issue regarding suffocation, the suffocation and/or strangulation, she testified actually to two events, which would, I believe, be recognized under the statute. That's the suffocation in the bed and the hands around the neck. I will not add an additional charge of that, although this court does believe, given the circumstances, that the court could do that, but just leave it at the one charge. And so, court having found that, the court will bind the defendant over to stand trial on both counts.
Judge,
Mr. Kittle, go ahead.
If we acknowledge receive the information, waive its reading, my client would stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
October 30th at 1:30 with Judge Slay.
October 30th, 2025, 1:30 before Judge Slay.
Judge, may I address bond?
You may.
Judge, I believe, if I'm not mistaken, he's under a $25,000, 10%. Is that accurate, Judge?
Let me see. I have 20,000 cash.
Okay. Would the court, Judge, I know this is, it goes to the credibility of the victim. I think there were moments shown that my, well, I'll just leave it at that. I believe that her credibility is suspect. That being said, I'm asking the court if it would release my client on a tether or give a nominal bond of $2,500, 10%. My client promises not to have any contact whatsoever, even though she's claiming it's his baby. My client is gainfully employed, and that he could be residing at his aunt's house. And Miss Langford, I don't have the address with me, but he can be gainfully employed, reside with his aunt, have a tether, and he's not a threat to the public, Judge. So for those reasons, I would ask you to please consider a bond. I know the court's made its decision regarding the bind over, but I think some statements are suspect. And based on that, Judge, I would ask the court to give some leniency to allowing my client to be released from jail.
Response.
Your Honor, in this case, we originally requested $50,000 cash surety. At this point, I would be renewing that request given the testimony heard today. Ms. Printup, the court heard her testify to two different incidents that would fit under the strangulation statute, as well as a DV incident that was separate from those incidents when he kneed her in the back. All this occurring while she was pregnant with their child. I mean, I have concerns given his history as well. He has a previous conviction from 2015 for 2 domestic violence counts, as well as an assault with intent to commit sexual penetration account that was DV related. So between that and the testimony the court heard today, I have concerns that he is a danger to the community and a danger to Ms. Printup. Also, given the fact that in this case, I just have general concerns given the facts of this case and the fact that after he does assault her, he then tries to call 911 and pretend to be her by saying that she's suicidal and has a knife. I mean, I have concerns that even if he's not contacting.
I don't mean. I'm sorry, I don't mean to interrupt you, ma'am, but that was not, there was no testimony. I'm sorry.
And Ms. Printup did testify to that he called 911 and it wasn't her, saying that she was suicidal. She did say that on the stand today. So I have concerns that he would try to do things like that indirectly. While he might not be contacting her directly, he would be trying to do things like that. So at this point, I would be re-requesting our original ask of $50,000 cash surety with no 10%.
With reference to bond in this case, I have some concerns. While certainly there's dispute regarding the testimony in the case, I will not raise the defendant's bond, but I'm not going to lower it either. I would consider, quite frankly, Mr. Killawall, the ability to lower his bond or think about another way to release the defendant. However, frankly, his behavior in court caused his own demise in that regard. He just couldn't control himself. I gave him the warning and tried to just tell him to not interrupt the proceedings, and he just couldn't do it. And I don't have great confidence that he would follow this court's orders. So the motion for bond reduction is denied. Maybe Judge Slay will feel differently once the case is in front of her, but I do not feel that way. So bond will continue.
Thank you, Your Honor.
Judge, I know you've made your decision, but I think in fairness to my client, it was out of exasperation, what was being said about him, but I'll respect the court's decision. Thank you.
And that happens with every defendant before us whenever we're hearing it. Some are able to control themselves, some aren't.
Well, that's it for today, everybody. I am so sorry about the audio. It seems that everybody who's on a different platform is having problems with StreamYard and Restream and all that. So I will see you tomorrow here at 3:00 p.m. for Judge Boyd. I believe that's Judge Boyd. Yeah, Judge Boyd. So I will see you tomorrow. You all have a wonderful evening. Ta-ta, ciao. I'll see you again soon.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, now I'm standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything